Slightly better motion and finally is not said philosophically not better disposal is secretary and the secretary that the authorities are disposal.
But you have moved the motion, right? It's a fresh matter. So it will come up. All right, it will. But why it is not being listed? What is the reason? That's all right, but why it was not listed earlier from 2024 to 25? What is the registry doing? It has already been filed. Or it will come up in the due course.
My lord,
Sir, it will come up.
My lord.
It will come up in
my lord,
it will come up in the due course.
My lord.
I have just taken this jurisdiction one day. Wait, it will come up.
My lord, may I permit it to...
In my case, my lord, urgency is that the premises where I am residing, there is a construction take up by the private respondent.
Very good.
The thing is that I made the representation to
Good.
the municipal authority.
Very good.
No action, nothing has been taken.
Very nice.
The thing is, but simultaneously, as the other side, they restricted me to entertain in the premises.
Go to the civil court.
No, my lord, in the premises. Now that hand belongs to me.
Go to the civil court, sir. Disputed question of land, whether it belongs to you, it belongs to somebody else.
It was a construction taking up by the private.
Construction, whatever private respondent will construct, if it is not in accordance with the rule and law, it will be demolished.
It will be. That is my point.
So it will be demolished. Let it construct 2 more floors, 4 more floors. Doesn't matter. No urgency, sir. No urgency. No urgency. Your residents having a problem, go to the civil court.
my lord, may I be
My lord.
permitted to
My lord.
mention one matter? There has been an unauthorized construction which was made in deviation to the sanction plan.
Very good.
And subsequently, the irregular construction was regularized by depositing 50% of the amount in the
Good.
KMC, which is illegal, my lord.
You'll see that.
And my
You'll
lord,
see that, madam. No urgency.
my lord, there has
My lord.
already been an order by
Right.
by the Honorable Justice Orijit Banerjee and Honorable Justice Apurva Sinha Rai, but it has
We'll
not been.
consider that.
Yes, my
We'll
lord.
consider, not now.
My lord, may I permit it to
No
mention
urgency.
on matter,
Yes.
my lord? What happened in this matter, my lord? I have filed one specific application for mutation of my property.
Good.
The municipal authority, in terms of the act, did not dispose of the same. I am suffering because my husband is suffering from cancer. I want to sell out my property. Because of mutation, I could.
Yesterday also I had a similar matter where a person was mentioning on his own. It will come up. In the due course, these matters will come up.
But it is not
It will
happening.
come up, sir. This will
23, it is not happening.
come up, sir. It will come up.
Restoration application.
Restoration.
Milord, may we permit to mention one matter for extension of interim order, Milord.
My lord, this is for inclusion, my lord.
No inclusion,
For
madam.
extension of interim order.
There's no
Milord.
urgency.
Matter is in the list, interim order.
Sorry,
For extension of interim
when
order.
is your interim order expiring?
Tomorrow, Milord.
Take it.
May I be permitted, Lordship?
Yes.
Tender matter blacklisted. This honorable court was kind enough to quash it. Again, it was relegated before the authority, my lord, without any reasoning, my lord. It was once again blacklisted. And my lord, a tender has been floated by the municipality in all probability, my
When
lord.
was the tender floated, sir?
My lord, the tender.
When was your blacklisting done?
My lord, all details, sir. My lord, I'll come back, my lord, tomorrow. Deeply up.
Lordship, I need to mention one matter that this matter already appearing, my lord, the justice for the procedural as item number 179. Matter, my lord, not taken up, but it's extreme urgency, my lord.
What is the
My
urgency?
daughter was retired in a road accident near my lord Juhu police station at Bombay, my lord. After that, my lord, she was cremated at Kolkata. Dead body was taken back to Kolkata, my lord. And my lord, I am not getting my daughter death certificate. My lord, all the travel benefit, everything was held up, my lord. Grateful.
My lord, may I permit it to mention, my lord, a matter, my lord, there's extreme urgency in the matter, my lord. A wide open space between 2 buildings, my lord, is being sought to be converted by putting up a tin shed roof and carrying out construction day and day. And my lord, it's happening
Good.
from day
Let
to day.
it
My
come
lord.
up, sir.
They are trying to, my lord, they're trying to convert it into a commercial space. My
Let
lord.
it come up,
It's
sir.
wholly unauthorized without
Very
any
good.
sanction plan. my
Very
lord.
good.
Lord, it's not been listed,
Very
my
good,
lord,
sir.
only praying for.
Very
praying
good,
for
no
listing.
problem. It will get demolished whenever the turn will come. Yes.
May I be permitted to mention one matter? My client filed a writ and for matter. The matter was
Motion नहीं करते न्यू मोशन नहीं करते
urgent is that now the Vidhannagar Municipal Corporation given notice that you vacate your home within 2 weeks. My client 70-year-old lady man. That is her home man.
Take it.
Stays with me.
Be permitted to mention a matter, Lordship. There's some amount of urgency. The petitioner's husband used to be an employee for KMC. During his working at KMC, my lord, he was accused of an offense. Lordship, he was taken into custody and trial happened. Lordship, during the trial, Lordship, he passed away. And while he was suspended, as in when the trial was going on, Lordship, he was suspended and he was getting a reduced salary. Lordship,
75%,
yeah, Lordship, reduction even less than that. Lordship, after
50%, that's
yes,
all
Lordship, after his death, Lordship, he has been acquitted. Lordship, the writ petitioner is his wife, Lordship, who is claiming for the enhanced money which she should have supposed to get because the husband has been acquitted, Lordship, subsequently.
When did the husband get acquitted?
Lordship, the
When
order
did you
came,
file this petition?
so writ petition filed in February 25th, 25.
Wait,
Lordship,
wait,
we're paying for just inclusion in the list.
wait.
My lord, challenging an order, a demolition order passed by the Vidhannagar Municipality. My lord, this writ petition has been filed. My lord. My lord, on 26th of March, they have given us a notice to vacate the property within, my lord, 2
Take
weeks.
it.
And may I be permitted to mention
Yes.
the matter for inclusion, my lord? The respondent municipality is not taking any steps against the respondent club. They have constructed one public toilet without leaving any statutory site space
That's all right, man.
just beside my boundary walls, my lord.
That's okay. It will get demolished if it's illegal. No urgency.
May I
Yep.
permit-
Yes, Mr. Banerjee.
May I have my lords kindly, my lord, to mention item number 2421 of the monthly list, my lord.
Yes.
This is a land, my lord, which has been granted to me by the KMDA, my lord. I am supposed to make constructions in terms of a plan. I want to put in a plan, but the KMDA has made an unconstitutional assessment assessing my land as regular land, whereas it should be assessed under special provisions of section 176. I made a representation. They heard me and they passed an order. The municipal commissioner passed an order. And in that order, my lord, still, my lord, the earlier thing has been approved. Now, my difficulty is, my lord, I am, my lord, in a catch-22. I can't go ahead with the presentation of my plan without clearing the areas. The areas, I say, have been made under a process which is dehors the
The
act.
arrears would have been made in terms of the property tax.
Yes, the areas of property tax, they are,
So why don't you go to the tribunal?
my lord, here, my lord, there is no order of the hearing officer under challenge. The tribunal is only
Yes.
restricted under section 189(5).
That's
to
right.
orders of the hearing officer which have been passed.
The order of the hearing officer, assessor and collector, you are challenging it.
Here, my lord, the order of the municipal commissioner hearing my representation, where there was a prayer for him to invoke his powers under 192.
He has not done it. You challenge the main order. The
Yes,
order
I
which
have
has been
challenged that
passed
order.
under 185(5), you challenge that order.
No, my lord, 189(5), subject to what falls, my lordship, my lord, is only against the order of the hearing officer fixing an assessment. We had sought, my lord, reopening of the assessment under section 192.
No urgency.
Against that, my lord, there is no appeal.
No urgency. And we'll hear it. Let it come up. We'll hear it.
My lord, may I be permitted to mention, my lord, application, my lord, for new connection of electricity. My lord, these matters, my lord, yes, my lord, but these matters, my lord, were assigned before your lordship. And my lord,
Gone back, sir.
my lord, on Friday, my lord, your lordship,
All matters gone back, sir.
my lord, is still in the cause list, my lord.
Check up with the registry. All electricity matters are.
May I have your lordship's kind leave to mention a matter? Lordship, this is a matter for withdrawal with liberty to file afresh. Yes,
With liberty to file afresh, you file it.
lordship.
Who's stopping you from filing a petition?
Sir.
I'm not following you, sir. What are you saying?
Lordship. Your lordship, withdrawal with liberty to file afresh. This is a
You want to withdraw a petition?
yes, yes,
Which
your lordship.
petition?
Which
Matter? Where is it listed? Which
Lordship.
number? Which
Your
item
lordship,
number?
WPA number 11139 of 2024.
Are you
Your
the
lordship, it's
advocate
not-
on record?
No, your lordship.
Get the advocate on record. Don't withdraw petitions where you're not the advocate on record.
Lordship, I am advocate on-
You're the advocate on record. Yes, tell me. Tell me, madam, what do you want?
I want to withdraw the matter and liberty to file a.
Show me which is the matter. Petition, which list, which is the item number?
Lordship, not in the list.
What do you mean it's not in the
I-
list?
I want to inclusion in the list and withdraw the.
You want inclusion and withdrawal?
Withdraw.
Sorry.
Lordship,
If it's not listed, you withdraw the petition. Have you filed it?
I want to withdraw and liberty to file a fresh matter, Lordship. Already filed, Lordship. 2024 matters.
Petition is already filed,
Filed 2024.
not listed.
on. Grateful, Lordship.
My lord, may I permit to mention, my lord, one inclusion matter, my
No
lord.
inclusion matter, right?
My lord, may I permitted to mention a new motion matter, my lord.
New?
New motion matter.
Wait. Matters will come up.
May I be permitted to mention of matter? This is the second round of litigation. The first occasion, the order was passed was not to make any unauthorized construction. So it has been directed to watch, but in spite of that, they have constructed the building.
Very good.
And
We'll send them to jail. Wait.
No.
Next.
Now what they are doing, what they are trying to regularize the matter.
We'll see that, sir.
They are regularizing.
If they are regularizing in accordance with law, they can do it. If not, you have a right to be heard. So no urgency. Yes.
May I be permitted?
No urgency, sir. No urgency in this
May I be
matter.
permitted to mention one matter?
Unauthorized matters, no urgency. No urgency. If you are being evicted, I understand. Your house being demolished, I understand. Here, no urgency. Yes.
Lord, may I be permitted to mention one matter regarding upgradation on the list of
Sorry?
upgradation in the list of
No upgradation.
My lord, may I permitted to mention one matter?
Yes, madam.
My lord, there is an urgency that in a residential building on a ground floor, eatery is been running.
Good. Since when?
And-
Since when?
Uh,
Since when?
Since 2000, my lord, since
Since when?
2013.
So what is the urgency, madam? Today they are not serving you food.
No, my lord. My
What
lord,
is the urgency?
Yes, my lord.
If
the
it can
urgency is
wait
that
for
building may catch fire.
from 13 till 2025, the building didn't catch fire. Everything was hunky-dory and fine. And
My
today
lord-
there's a problem.
My lord, maybe I'm wrong in the year, as it has been filed in the year
No
2024.
urgency, madam.
Lordship,
May I be permitted to mention one matter, my lord? My lord, whether building is constructed as per the plan issued by the corporation authority and the building permit was issued, my lord. Thereafter, some main and agents of the corporation is disturbing my construction, my lord. I have developer obligations to hand over the possession to the flat owners, my lord.
You're a developer.
Yes, my lord.
Wait.
Lordship, may I?
Not owner of properties. Wait.
Lordship, may I be permitted to mention a matter for upgradation in the list, Lordship? This matter relates to unauthorized construction, and despite the demolition order passed by Lordship Amrita Sinha and Justice Jai Sengupta, the Bhatpara municipality is not taking any adequate
Very
steps
good.
to demolish.
They will go to jail if they are not doing it.
Well,
File a
may I be
contempt.
permitted to mention one matter
Yes.
for inclusion, my lord. This is a motion from 2024, and my lord, the petitioner's water supply connection has been stopped. My lord,
What is stopped?
water supply connection, my lord.
Lordship, may I permit to mention one matter, Lordship? There is huge unauthorized construction, Lordship.
Unauthorized construction, madam, let it come up, it will get demolished. later.
Petitioner could not open up his window last 5
File a
years,
civil suit.
Lordship. Building will fall down any day, Lordship.
What will fall down?
Building.
Building?
Unauthorized construction.
You will get compensation.
Lordship, may I be permitted to mention one matter for upgradation, Lordship? Some miscreants, Lordship, managed the KMC to get the change the nature of my property into Thika tenancy property, Lordship, and they recorded their name accordingly as Thika tenants.
Good.
And now I have made one representation
Very
to the,
good. So
before
when
the
did
case.
this happen? When did this?
This happened in 2025, Lordship. This matter is of
I'm
2025.
not asking. When did they change your name in the Thika tenancy?
Lordship, I have to check it.
Check it later and mention it. Yes.
My lord, may I be?
My lord, I am a petitioner, so
Take your time. Nothing to be worried about. What do you want to say?
my clients suffers from heart disease and a senior citizen. His water supply is not being constructed, but there is a inaction or non-action on the part of the.
He's not getting water connection.
Yes, on his occupation.
My lord, may I be permitted to mention it is for the inclusion in the list.
No inclusion.
My lord,
Item number 40, my lord, I am mentioning kindly if you accommodate me to adjourn the matter till 9.
Is the other side here, madam?
I have already talked with them.
Is he here?
No, not now.
Get the other side.
My lord,
Mention, please don't mention without the other side for any accommodation. Tomorrow, I don't want the other side lawyer to come and tell me that you have given a date without my presence being there.
my lord, I have served other side.
Madam, not now. No inclusion. Yes. Yes.
Construction, but it's
No illegal construction. Yes, call out the list. Yes, yes, madam.
My lord, I am appealing for the corporation.
File your report.
Corporation.
Where's the council? Not this week.
Item number 2,
Your Lordship, in item number 2, I am for the petition. I was led by Mr. Srijit Chakraborty. He was making submissions with regard to that premises which was P2549 renumbered thereafter in my property, construction made.
Yes,
On
yes.
the last location, corporation was supposed to bring the documents, Your Lordship.
Yes, Mr. Ghosh.
Well, I have come with the document. First of all, I find the petition which has been supplied to us. It is the not complete papers because 15,
Pages
16 to 19
are missing in both the copies.
Give him the
pages are
complete paper
missing.
book, sir.
I will serve a first copy, Your Lordship. In detail.
Give the complete paper book at least to the corporation.
To the private respondent also.
Private respondent also. Even they don't have the complete paper book.
This point number 6.
Give the complete paper book to Mr. Ghosh and Mr. Banji.
I will. In course of the day, I will.
Learned counsel for the, just take down. Learned counsel for the corporation states that the entire paper book has not been given to him. The same plea is also taken by the learned counsel of the private respondent. Petitioner states that, counsel for the petitioner states that he shall supply a fresh copy of the paper book during the course of the day. Let this matter be listed next week. Mr. Ghosh, I just want to point out that there is an order earlier passed in the earlier round of litigation.
I have understood well. I have understood because I find my lord that the now presently an order of the authority concerned is under challenge, which has passed in terms of the direction of this honorable court. Now they are questioning about their particular premises. Now the huge according to them they purchased from one gentleman. What is the position? I have checked up on all the records. I'll be placing before the lordship the position because I privately I found that on a particular day when they purchased the property, they were not put into possession of that particular property which they purchased. And the other party for which one Mr. Banerjee is appearing, that property was purchased from the Kolkata Improvement Trust. They had certain schemes.
Today the report which you have filed. It says that only one property exists. The other property doesn't exist at all.
I find the original, what is the 49.5, that was one point of time, the 49.5 was there, from which I finally he purchased the property. But the thing is this, my lord, when he purchased in 2010, he was not put into possession of the particular property which he purchased. And mutation had taken place, my lord, one visit mutation. Well, that was not, my lord, taken into consideration, any document or a boundary and all the other things. Now the record, my lord, says, my lord, that they had, my lord, their names have been recorded since 2001. The respondent number, my lord, the private respondent. And they had been making construction on the basis of the sanctioned building plan. And 49/5 once, my lord, in respect of the parcel, my lord, that was sometime it was changed to 49/49A. The base map which we have, my lord, I find, my lord, that the base map indicates that 49/5 once, well, it was, my lord, towards the north side, possibly north side of the premises, my lord, for which, my lord, Mr. Banerjee is appearing.
Why don't you do the demarcation as per
But I
the,
cannot make the demarcation because my lord,
there was a direction of this court to do the demarcation, sir, so you have to do
my
it.
lord, demarcation, my lord, if the property is not found, of course, my lord, I may, but the court, my
You
lord,
have to, because the earlier round of litigation, there's a specific order for demarcation.
the court at the same time, my lord, directed that if the property is not found, my lord, it is to be noted, my lord, that whether it is physically existing or not.
Where will the property disappear, Mr. Ghosh?
My lord,
Where will the property disappear, Mr.
the
Ghosh?
disappearance is not, my lord, it is, my lord, identified by the person, my lord, who is, my lord, owning the property in my
Mr.
lord,
Ghosh, there is some hanky-panky by your department. I will definitely order a CBI probe in this.
So that your lordship,
I'll put quietus to this whole
so
thing.
your lordship may, of course, my lord, do that, but if your lordship finds, my lord, something wrong in the, on the issue, my lord.
This can't disappear. Land doesn't disappear. All this argument is absolutely flimsy, completely flimsy. This is just to cover up, nothing else.
Well, I'll
There's a
come on
big-
this show.
There's a big racket here. You have to see this.
What's the
Mr.
racket,
Ghosh,
my lord?
with your assistance, this kind of argument, flimsy arguments, doesn't really impress the court at all. You know, when you are here, you are standing before this court, we expect better
No,
arguments.
man, I'll
better
want something, my lord, what the record, my lord, speaks of, my lord, that.
Please have a look,
and your
Mr.
lordship,
Ghosh,
my
and
lord,
you
of course,
please, you personally have a look at it.
my,
You please personally look into
my,
it. There's something much more.
my.
Please have a look at it. All right. You supply him, we'll have it next week.
I will, in course of that. I'm not.
Item number 3.
ये matter. Yes. Let us see the rejection.
Yes. Comes to page 32.
Sinha, you are appearing. Yes. Yes. Read it, sir. Read it.
क्या होगा एक में কিছুই বলছে না ফ্রেশলি অ্যাপ্লাই করতে কিছুই
Despite having clarification to this basic requirement, I was not but the additional is that the heading of this I will have indicated that now I have also indicated in my paragraph of the key. The case of double naming and I will keep one particular paragraph. After the of the beach, paragraph number 3. It's organ of fact. Absolutely hit by the
স্টেট তো পার্টি আছে
Yes.
all the fact.
আইএনসি রেসপন্ড
Respondent number 6. Don't I think that respondent number 6? I have get the private respondent. Which will get before the order data. I'm not playing around. I have kept them as a party respondent. As private respondent. Taking into fiber of fact, special from respondent number 6 that the respondent number 6 is also days as a respondent number 9. And respondent number 8 and 9 as expired.
But these are clarifications which is left with me. I was not given an opportunity to explain that they are and that's the reason which I have questioned. So that opportunity I missed. I didn't think that that opportunity was available for the purpose of it. I would have verified along with the erstwhile owners had made a part of proceedings of it. So this is my case.
Yes.
May I hand over a bunch of instructions? Which
Or I beg to for the municipality, my lord.
kindly sees paragraph number 3 onwards at page number 2.
The answering respondent would be me. Answering respondent would be me, my lord.
Please do answer.
That is fine.
Sir, bro.
Huh? Oh, यार किया
बालू ही दिए जी, खराब। Resubmit করতে।
resubmit করতে কার কাছে resubmit সেটা তো municipality বলবে government of West Bengal কি বলবে government of West Bengal কি বলবে
তুমি বলো।
যেটা দলিল দিচ্ছে that is not
আমি স্যার লিখে দিই।
আর ও তো আমাদের কাছ থেকে নিতে পাবে
যা হোক, if you will not remain present, I have to submit it.
there is no কি বলে there was no
Yes.
Kindly see the last line that there's a rider that if the applicant has a further scope to resubmit a mutation
Submit application.
in the corrected manner.
Yes.
Well, I would be having two preliminary objections regarding the maintainability. Municipality has not been made a party. If your lord checks up there, it's a body corporate. Under section 13(2), it's mandatory for subject to lordship kind correction. And if he considers the state of West Bengal to be the principal respondent, it has also not been impleaded as a party. Only the officer concerned has been. 226 rules, rule 24 specifically states that the state of West Bengal should be made a party for the maintenance. These are the two preliminary objections, and if your lordship considers these two, apart from that, my lord, I come to the main merit subject to your lordship's kind consideration. My lord, he has impleaded dead persons here over there here, and the basic difficulty the municipality was facing, my lord, the deed that was your lordship has gone through there in some of the deed that was my lord served upon the municipal uploaded, my lord, through the portal, my lord, that does not tally with the municipal records which was there in the earlier, my lord, assessment, my lord, that was done by the predecessor in interest of the petitioners, my lord. So that is the only thing, and my lord,
Let him file a fresh application. You can.
yes, they can do it if they
Points have been ventilated in the
It has already been.
which I have submitted.
if they can file it afresh if they want to with further details, because the existing record does not tally at all, and the deed, my lord, the schedule of the deed that is present, that they have, my lord, annexed and presented to the municipality, there's lots of difference between the, my lord, quantum of land as well as the legal layers. The legal layers ought to have been made my lord, reflected in the, my lord, title of the deed. Erstwhile there are 5 owners, now there are 3 owners, my lord. He has already, my lord, stated that they 2 have died, my lord. Where are the legal layers? They should have been.
Kindly see, lordship, the instructions, page number 3. A. All the points that my learned friend is taking, this was all ventilated in the assessee owner's name as per assessment records and vendor's name as per deed are not
But
same.
this is the instruction of the municipality. Yeah, same thing.
Anybody has to place it.
It has come from the
Yes,
municipality.
that has been uploaded, and my lord, it has been given to it.
The crux, the inference is that he can reapply, resubmit a mutation application before the concerned municipality.
Where do you? Okay, he's also agreeing to the resubmission of the application.
Yeah, we do not have any objection, my lord, subject to the documents of.
Or take down. The petitioner has preferred the present writ petition seeking mutation of his property. property situated at premises subject plot Moza Babanpur, situated at jail number 1, Khaitan number 2878, police station Titagarh, district North 24 Parganas. Petitioner submits that he had made an application for mutation and the same was rejected by the by the respondent number. What is the respondent number?
2 and 3 is
Respondent number. Respondent municipality.
I will be one, your lordship.
By the respondent municipality. What is the date of rejection?
But 16th of November 2022.
16th of November 2022. Learned counsel for the corporation states that the said application had been rejected on the following grounds. Yes.
Obviously. আমি বললে এক্ষুনি আবার আটকে যেত দেখুন 12 থেকে 30 মে
Though it is further stated by the counsel for the corporation that they are ready to consider petitioner's application if the same is resubmitted with proper details and necessary documents. Full stop. Learned counsel for the petitioner states that he will make a fresh, he will resubmit his application within a period of 2 weeks. Full stop.
My lord limits that procedure to be a time frame one.
Within a period of 2
he has
weeks.
to apply through the portal. There's a portal.
It is further submitted by the counsel for the petitioner that he shall be satisfied if his application is decided in a time-bound manner. Full stop. In view of the said submission, this court directs the municipal corporation. Respond number?
2 and 3. Municipality has not been a
Who will
party.
decide the application?
But the mutation,
Assessor and collector?
Kasa collector.
Respond number 3, the
Three-
assessor and
three
collector.
perhaps.
North.
Assessment in charge.
Assessment in charge, North Barrackpur Municipality. Shall decide the application of the petitioner if the same is made within the time prescribed by this court within a period of 4 weeks thereafter, after affording from 4 weeks thereafter, after affording an opportunity of personal hearing to the petitioner and all the necessary parties by way of a speaking order. With the above direction, the presented petition is disposed of.
But subject, but one point, but the difficulty is that it has to be uploaded in the portal and there would not be perhaps
Within
any.
2 weeks. He will
No,
do
no,
it
that is
within 2
there. All the relevant documents should be there. Otherwise, because we have to answer through the portal.
I'll give you more time within a period of 8 weeks. I'll give you 8 weeks.
No, not the time factor. All the
I'm giving
documents
you
should be-
time. Suppose he comes, he doesn't have the documents. You can ask him to place the documents on. So I'll give you more time for that within a
Yes,
period of
6
8 weeks.
or 8 weeks.
Instructions kept with record.
Instructions are taken on record.
Grateful, your lordship.
Barrackpur, actually. Oh, wow.
Question number 4.
This is the matter where my lord was hearing us on the point of maintainability.
He already
No,
submitted.
No, yeah, no.
I was in the midst of my submission. ठीक है, अच्छा। My lord, we formally placed reliance on one decision. My lord, 2 or 3 more are there. And my lord, I just indicated the facts why, my lord, according to my lord, our humble submission, a new cause of action has arisen post disposal of the my lord, previous round of litigation. My lord, just my lord, for a brisk recapitulation, I'm sure my lord,
Please do that. Please do that. Yes, tell me.
so, my lord, page 52, my lord, is the last order passed in the earlier round by my lord, an honorable coordinate bench. If my lord kindly turns to my lord, page 54 once, my lord, the ordering portion. My lord, the direction was municipality is directed to take steps to issue trade license in favor of the partnership firm. Steps shall be taken to issue the license. So, my lord, this was not a direction as such, my lord, that you issue. You take steps. Now, my lord, pursuant to this order, my lord, they took steps, which, my lord, according to us, are, my lord, not warranted in law. They, my lord, called upon, my lord, my lord, rival group, my lord, in the partnership firm, my lord, who are no more there, my lord, in the partnership business. And my lord, took objection from them, invited objection from them, and on the basis of that objection now says that, my lord, they are not in a position to renew, my lord, the trade license. Now, my lord, this partnership dispute is a subject matter of arbitration. My lord, there is, my lord, a suit where, my lord, an interim order has been passed, which has also been taken note of by the honorable coordinate bench, my lord, in the previous page. If my lord kindly just have a look at page 53 once. My
Last
lord,
line.
yeah, my lord has, my lord, taken note of that. So, my lord, suit is there, arbitration is there. Those are, my lord, for those, my lord, learned fora, my lord, to take a decision on the, my lord, intercept disputes between the partners. My lord, this authority, my lord, municipality cannot, my lord, delve into those issues. My lord, that is absolutely without jurisdiction. Now, my lord, before I satisfy that, my lord, they have acted, my lord, in excess of their jurisdiction. May I, my lord, formally cite 2 more decisions that, my lord, contempt may not be, my lord, a proper remedy for me in view of the facts of this case. If my lord kindly, my lord, just take the trouble, Justice Shubha Kamal Mukherjee দেখিয়েছিলেন. Kindly take the trouble, my lord, to have a look at, my lord, the reported decision of 2003, volume 1, CHN 154, which, my lord, we handed over. Paragraph 6, my lord, has possibly, my lord, taken note of. 2003, volume 1, CHN 154. May I, my lord, hand up one more copy?
Please. You have given me 2 judgments.
Yes,
One
my
of
lord.
Justice Mukherjee, one of Justice Basak.
Yes. My lord, paragraph 6 was, my lord, again subject to correction. Pattern point says, my lord, contempt is not a substitute, my lord, for a second writ. And if, my lord, just have a quick look at the facts of the reported decision.
Yes.
So, my lord, this is one. My lord, there is a Supreme Court decision which, my lord, we formally, my lord, cited but could not place the paragraphs because of paucity of time last day. My lord, 2007, volume 7, Supreme Court cases, page 689. Volume 7, Supreme Court cases, page, my lord, 689. Kindly, my lord, just paragraph 31 onwards. The 31, paragraph 31, my lord, will kindly find at page 699. My lord, internal page 11, my lord, of the judgment. 699, my lord, would rather be, my lord, easier to find out. My lord has kindly, my lord, arrived at paragraph 31 at the foot of, my lord, page 699.
Yes.
If my lord kindly turns over the page, my lord, the last 4 lines of this continuing paragraph 31, then my lord 32, 33. My lord, on the same proposition of law.
Just
My lord,
read
may I
it.
please?
Just read it.
May I please? My lord, I am reading from the last 4 lines, my lord, 4th last line of, my lord, paragraph 31. The writ petitioner therefore had legitimate grievance against such direction. A fresh substantive petition hence could be filed by him, and since he was entitled to such relief, the division bench was justified in granting the prayer. We are of the considered opinion that once a direction is issued by a competent court, it has to be obeyed and implemented without any reservation. If an order passed by a court of law is not complied with or is ignored, there will be an end of the rule of law. If a party against whom such order is made has grievance, the only remedy available to him is to challenge the order by taking appropriate proceedings known to law. But it cannot be made ineffective by not complying with the directions on a specious plea that no such direction could have been issued by the court. Then, paragraph 33, skipping over 4 lines. The matter can be looked at from another angle also. It is true that while granting a relief in favor of a party, The court must consider the relevant provisions of law and issue appropriate directions, keeping in view such provisions. There may, however, be cases where on the facts and in the circumstances, the court may issue necessary directions in the larger interest of just keeping in view the principles of justice, equity, and good conscience. Take a case where a express injustice has been meted out to an employee. In spite of the fact he is entitled to certain benefits, they had not been given to him. His representations have been illegally and unjustifiably turned down. He finally approaches a court of law. The court is convinced that gross injustice has been done to him and he was wrongfully, unfairly, and with oblique motive deprived of those benefits. The court, in the circumstances, directs the authority to extend all benefits which he would have obtained and he not been illegally deprived of them. Is it open to the authorities in such case to ask that as he has not worked, he would not be granted the benefits? Upholding of such plea would amount to allowing a party to take advantage of his own wrong. It would perpetrate injustice rather than doing justice to the person wrong. Milord, why I place reliance on this? Today, Milord, it cannot, Milord, lie in the mouth of the municipality saying that they have taken steps pursuant to the previous decision passed by, Milord, the Honorable Coordinate Bench, and the decision and the action that they have taken, Milord, is justified in law. Milord, we are against that action of, Milord, calling upon us for this purported hearing. Milord, this in the guise of compliance, what they are doing is not, Milord, what they are entitled to do in law. Milord, the third decision. Milord, this is reported at 2003, Volume 4, Calcutta High Court Notes, page 148. Milord, Honorable Coordinate Bench's decision. Milord, kindly come to paragraph 35, Milord, straightway.
Yes.
Milord, will kindly take paragraph 35. This writ petition is virtually a petition before this court for enforcement of the order passed by this court.
Yes.
In the earlier writ petition. Milord, like Milord, in our case, a second writ petition for enforcement of the earlier order is very much maintainable. Then, Milord, some decisions are cited. Kindly take, Milord, the quoted portion of, Milord, paragraph 36, which is quoted, Milord, from a previous decision of my Lord's Milord court. It is therefore same. Correct. So, Milord, this is the same proposition of law is being reiterated, Milord, several times.
Yes.
Milord, one more.
No need.
Milord, should I multiply? Now, Milord, may I come, Milord, to the merits of the case?
Yes, sir.
Yes. Now, Milord, kindly have a look at, Milord, the facts. Kindly take the trouble, Milord, to have a look at the order my Lord has seen. Now, Milord, kindly see what they did, Milord, after the order was passed. Kindly, Milord, turn to page 72, 80, and 86. Milord, this is what they did, Milord, once the order was passed by the Honorable Coordinate Bench in the previous round of litigation. Milord, they are calling, Milord, me, Milord, I am there, Milord, number 1, and then, Milord, number 2 to 1 and 2, and Milord, 3 is, Milord, the rival partner. They have called him, who has nothing to do with the business. You are hereby asked to appear for a hearing at the chamber of the undersigned on the aforesaid date and time with relevant documents supporting your statements in the hearing. Milord, they had no business, Milord, to call upon the addressee number 3, Milord, to support his case. He could have had no case before the municipality. Then kindly, Milord, take page 86 once. Milord, this is not legible. Kindly turn to, Milord, 86A, the typed copy. Same thing. Milord, after this so-called hearing, Milord, I say these hearings were all, Milord, farcical proceedings. These were absolute IUs, Milord, in the guise of compliance of the previous order. Milord, nothing, Milord, positive or negative, Milord, came from them. no result, no fate, my lord, of these purported hearings is disclosed. Now, my lord, kindly have a look at the statutory provision that deals with, my lord, renewal of trade license, which is, my lord, certificate of enlistment. Kindly take, my lord, section 118 of, my lord, the Bengal Municipal Act 1. Miller deals with certificate of enlistment, which Miller we colloquially call Miller trade license, of profession, trade, and
Just a minute.
I'm sorry.
Municipal Act.
Yes, Miller of 1993, section 118. Every person engaged or intending to be engaged in any profession, trade, or calling as specified in Schedule 1. It's nobody's case that I do not fall under Schedule 1 because there was already a trade license. We are asking for renewal only. And as may be detailed in the guidelines issued by the state government for the purpose in any municipal area, this is within Barakpur municipality, either by himself or by an agent or representative, shall obtain a permanent certificate of enlistment or provisional certificate of enlistment, as the case may be, as per modality specified in subsection 2, or get the permanent certificate of enlistment renewed on or before expiry of the validity period from the executive officer of the municipality, or in his absence from the officer authorized to function as the executive officer, upon presentation of an application together with such application fee as specified in the guideline at such rates not exceeding rupees such and such. Application form for the purpose shall be available either from the municipal office or upon payment of such fee, provided that the provisional certificate of enlistment shall not be renewable on or before completion of the validity period of provisional certificate. This is not applicable to our case because we are not talking about provisional enlistment. Then subsection 2. Notwithstanding anything contained in subsection 1, the application for enlistment of profession, trade, or calling may also be submitted through web portals as may be determined by the state government, along with manner of submission of applications mentioned in subsection 1. In the case of applications under this subsection, where any or all necessary statutory clearances remain pending, provisional certificate may be issued. So, even if other licenses are yet to be issued, provisional enlistment is permissible under the law. And where all the statutory clearances are available, permanent certificate may be issued. We are having a permanent certificate. Recipient of provisional shall obtain all statutory clearances, then permanent certificate would be issued. And I am not troubling your lordship with the rest of it. That has no relevance for our purpose. Then 119. The executive officer or in his absence, the officer authorized to function as the executive officer shall, after making such inquiry as may be necessary, and within 30 days of the receipt of the application, grant him a certificate of enlistment if the application is in order. Now, what is the scope of inquiry? Because statute says, after making such inquiry as may be necessary. Our Honorable Coordinate Bench has indicated what is the limited scope of inquiry for a municipality while granting or renewing a license. This is an judgment reported at 2018 volume 5, Calcutta High Court notes, page 404. Kindly turn to paragraph 8. Deals with clearly the limited scope of inquiry of the municipality for granting or renewing a certificate of enlistment. May please paragraph 8. May read it out for your lordship. The scope of inquiry under section 118 was of the Act of 1993 was considered in such and such. It took into account provisions of section 118 of the 1993 Act and rules 80, 81, 82 of the West Bengal Municipal Finance and Accounting Rules. Section 201 of the Act of 1993 was not placed before it. Indubhushan Bhattacharya Supra was also not placed before it for consideration. It considered the issue whether production of consent letter of landlord or owner is a condition precedent for grant of certificate of enlistment to an applicant or not. It relied upon 3 reported judgments of the Calcutta High Court, namely such and such. Sorry, Miller. Vinod Jain, Supra, Abdul Rashid, USG Financial Services, etc., considered the scope of inquiry under Section 199 of Kolkata Municipal Corporation Act 1980 prior to its amendment by virtue of the Calcutta Municipal Corporation Act 1992. The Act of 1992 deleted Section 200 and introduced Section 199 into the Act of 1980 with retrospective effect from such and such. Subsection 2 of Section 199 requires the Municipal Commissioner to either grant or reject the application for certificate of enlistment or renewal thereof after making such inquiry as may be necessary with this perimeteria provision. Vinod Kumar Jalan Supra is of the view that the scope of inquiry does not enable the municipal commissioner to decide any question of title to an immovable property. Abdul Rashid Supra is of the view that a businessman carrying on or intending to carry on business within the limits of corporation acquires a right to certificate of enlistment, incurs a liability to pay tax, and that corporation has no right to refuse the certificate or tax. USG Supra is of the view that inquiry contemplated does not envisage a detailed inquiry on particularly inquiry relating to legality and validity of the right of the applying. Harvinder Singh is of the view, right of the applicant applying Harvinder Singh is of the view, if a trader has a settled place of business, but I'm there, the business is still on, the municipal authority will not inquire into any dispute with regard to the property and enlist him as a trader. Then Miller 10, the authorities noted above are of the consistent view that the only inquiry required to be undertaken is whether the applicant is carrying on or intending to carry on any business. So that's the only scope of inquiry, which is why, Miller, there was an order of injunction passed in my favor in suit, Miller, in the previous round of litigation. Now, Miller, they want to, Miller, usurp a jurisdiction. Miller want to cloak themselves with the authority of civil court, with the authority of Miller arbitrator, and Miller to delve into the issues relating to title, partnership dispute. They have, Miller, in my most humble submission, no business to do that. So, Miller, kindly, Miller, direct them to, Miller, immediately renew, Miller, the certificate of enlistment. Miller, these are, Miller, my most humble submission.
Miller, regard Miller maintainability of writ petition, Miller, I would like to submit that the decision submitted by learned friend, the decision is not applicable in this case because there is no longer res integra the issue. Second, writ petition is maintainable for implementation of the earlier order passed by this honorable court. But here, he directly approached this court, the same PR made earlier, because the issue already been decided by this honorable court in the earlier matter. And my lord, here the petitioner prayed similar order, similar prayer, my lord, made earlier. So the decision for implementation of this order of the earlier court was not, my lord, prayed before this honorable court, and the decision cited by my learned friend is not applicable in this case. Here, doctrine of res judicata or, my lord, constructive res judicata is apply in view of the order passed by the Honorable Supreme Court. If the party is same, my lord, if the issue already decided by the earlier court and, my lord, prayer is same, then, my lord, doctrine of res judicata will apply in the next matter. If your lordship, my lord, hold that if this petition is not maintainable, then threshold, your lordship, dismiss it. So far, my lord, second, my lord, submission, the prayer made earlier, my lord, an order was passed by this honorable court to take steps. That is pending before the municipality.
Since when?
If the municipality failed to, my lord, take step in terms of the order passed by the earlier court, then, my lord, contempt lies, not second petition.
When,
Yes, my lord.
since when are you taking steps? For last 2 years?
No, no, my lord, that is pending because the objection is there already.
So when will you decide? After 10 years?
No, no, no. Immediately, immediately that will be decided.
Immediately means?
Immediately, means, my lord, after, my lord,
What's the last letter written to them?
Milord, page 77, 10th December 2024.
last page.
Milord, that was, Milord, my renewal of request.
86, page 86.
Yes, 86.
December 24.
সেটাই বললাম।
7 months, you are
Then-
still deciding?
Yes.
Yes.
Within 1 month.
What is the direction of the court?
To take steps within.
What is the direction of the court, sir? Read the order to take steps.
Page 52.
Read the order, page 54. Is there a time bound?
Yes, yes, time bound, man. Accordingly, the municipality is directed to take steps to issue the trade license in favor of the partnership firm and the company and Messrs. Joykali Bhandar. Steps shall be taken to issue the license at the earliest, but positively within a period of 4 weeks.
Have you done that?
No, no, that,
Why?
that is pending, my lord.
Why pending? Why you have not decided?
My lord, my instruction is the decision will be taken by the authority immediately. I already took instruction.
Decide in 3 days. 3 days decided. Take down. Learned counsel for the present writ petition has been filed, alleging non-compliance of the order dated 10/5/2023, passed by this court in writ petition number 313 of 2023, whereby the respondent authorities have failed to renew the trade license of the petitioner. Counsel for the petitioner submits that in pursuance of the order dated 10/5/2023, passed by this court in writ petition number 313 of 2023, the respondent has held hearing on. When was the hearing held?
Milord,
Last
just
order.
indicate 86. Milord, I'll just indicate.
December 13 December 2024.
18 December was the date of hearing. 13 December was the hearing notice.
18th
18 December.
2024, however, till date, his trade license has not been renewed, neither any decision has been taken on the same.
Milord, may I interrupt for once, subject to my last kind Milord approval? Kindly, Milord, turn to 86, say once. Milord, I'll just indicate one thing. Kindly see who has heard and before whom, Milord, the hearing was proposed to be taken place. Chairman, my Lord has seen, Milord, the provisions of the law.
That's all right. Full stop.
Any decision would be done.
Learned counsel for the respondent states that takes preliminary objection that the present writ petition is not maintainable, since the petitioner has preferred the present writ petition on the same self-cause of action, which was in the earlier round of litigation and writ petition number 313 of 2023. Full stop. It is contended by the respondent authority that they are taking steps in pursuance of the directions passed by this court in the earlier writ petition. Full stop. Learned counsel for the respondent states that the present writ petition is barred by res judicata, and the same shall be dismissed. Full stop. Petitioner has relied on the judgment passed by, which is the first one?
Milord, Justice Shubha Kamal Mukherjee. Milord, I'll indicate. Okay, this is a copy.
No, no.
Passed by this.
Milord, this was 2003, volume 1, CHN 154.
Not 2003,
Volume 1.
CHN 154
Yes.
of the decision rendered by this court in Vivekananda Mandal versus State of Rajasthan, reported as 2003 1 CHN 154, wherein the petitioner states that it is a settled law that the court had held that it is a settled law that the second writ petition is maintainable for implementation of an earlier order of this court. Further impresses upon the court to submit that the court must issue proper direction for the implementation of its previous directions, and that wherever the order has been issued by the bench, the same shall be complied. Full stop. It further states that an act done in willful disobedience of a court order is not only contempt, but, also, an illegal and invalid act. Full stop. The language used in Article 226 of the Constitution of India is couched in comprehensive phraseology, and the said articles recognizes a wider power of the high courts to remedy justice wherever it is found. In view of the said submission, it is apparent on the face of record that this court-wide order dated 10/5/2023 had given a direction to the respondent, relying on the order passed by the learned civil judge, wherein they had restrained the defendant from withholding the renewal of the trade license of the petitioner. And accordingly, the municipality was directed to take steps to issue trade license in favor of the petitioners, in favor of the partnership firm, MS Joycali Oil Mills and Company, and MS Joycali Bhandar, full stop. Further directions were issued by the court for the municipality to take steps in issuance of the license, and the same was to be complied within a period of 4 weeks from the date of communication of this order. Full stop. Learned counsel for the petitioner states that despite clear directions being given by this court, they have been made to attend hearings, and till date, no order has been passed, even after elapse of so many months, and in complete disregard of the directions passed by this court in the earlier round of litigation. Full stop. This court takes strong objection to the fact that despite clear directions being passed by this court, wide order dated 10/5/2023, the respondent is dragging their feet and are delaying the proceedings. Full stop. Respondent so-and-so appearing for the municipality states that they shall pass a speaking order and comply with the directions of this court within a period of 1 week. Full stop. In view of the said submission, the present writ petition is disposed of by directing the respondent to comply with the order, with the earlier round of direction passed by this court in writ petition number 313 of 2023, wide order dated 10/5/2023. Full stop. Within a period of 1 week from the date of communication of this order. Full stop. With the above direction, the present writ petition is disposed of.
Would it be my lord's kind pleasure, my lord, to direct them also to issue, my lord, renew the trade license within a week, because that
in terms of direction.
In terms of direction, nothing more.
Grateful. Great. Grateful, ma'am.
Item number 5,
My lord, in this matter, we have challenged the order dated 10th January 2025, passed by the Commissioner, Vidhannagar Municipality. My lord. There are two limbs to the order, my lord. The certificate of enlistment has been, my lord, sought to be cancelled, my lord, on two grounds. Number one, that the consent to operate from the owner has not been taken.
Who appears for the municipality?
They have been served, my lord. FTV service.
Which municipality is this?
My lord, Vidhannagar Municipality. Keeps it after fortnight time, my lord, because my lord, I would be relying upon two notifications. I have got hold of one notification. The second, my lord, I have not been able to lay hands of, my lord. Under RTI, I have to make the application, my lord. I shall come back if my lord grants me a fortnight's time or 3 weeks time, my lord.
Have you served them?
Yes, my lord. They have been served, my lord. I shall be relying upon
Not
my lord,
list
at
after
least
2
3
weeks.
time, my lord.
List after 3 weeks.
May I submit the affidavit?
No.
Item number 6, my lord. Mr.
Yes.
Subhasis Bandyopadhyay is appearing on behalf of the municipality. He is engaged in another court, my lord.
My lord, I
Kindly
for
not
the
today, my
petitioner,
lord.
My lord, I only want
Only,
consideration of my
he is engaged
representation.
in court number
Page 20,
655, my lord. In
Very
a
simple.
contempt matter, my lord.
We'll
My lord,
pass it
very
over.
simple.
We'll pass it over. Ask him to come. Who's the counsel?
My lord, kindly not today this matter. Kindly, my lord. One day accommodation.
Not today.
item
I am
number
for,
7,
I am for the
As
petitioner,
per
my lord.
Urubiya Municipality, respondent number 2 and 3.
Yes.
My lord, the municipality, the plumber of the municipality went to the spot to give water connection in the premises of the petition. But my lord, one neighbor, Mr. Robin Das, he strongly resisted and chaotic situation was created. That's why plumber and the menials of the municipality.
Take police protection.
My lord,
Take police protection and do it.
my lord, it will also would be pleased to give, direct police to give municipality has no objection.
No objection.
Yes.
The present writ petition has been filed seeking domestic water connection.
My lord, petitioner has already
Just-
paid
just,
the necessary
the
cost
respondent.
also.
The respondent. The respondent for Uluberia municipality declares and states that the officials of the respondent municipality had visited the site of the petitioner's property. Full stop. They are in a position to grant water connection, but due to strong resistance from the neighbor, they were unable to grant water connection to the petitioner. Full stop. Learned counsel for the respondent states that if adequate police protection is granted to them, they will be in a position to effect water connection to the petitioner's premises. Full stop. This court, in view of such statement made by the counsel for the respondent, this court directs the. You have made them a party?
No, my lord.
Police station.
You have not made state a party.
Yes, problem is that he has not impleaded the police station. The local police station should be impleaded.
My lord,
police station.
Uluberia police station. হ্যাঁ।
This court directs the, which is the police station?
Uluberia police station.
The
তাই তো মনে হচ্ছে।
OC or inspector in charge? Who's this? IC, OC?
Yes, my lord.
Who's it? IC or OC?
OC, my lord.
OC, Uluberia Police Station, to provide adequate police protection to the respondent in providing the water connection to the premises of the petitioner. Full stop. Learned counsel for the, with the above direction, the presented petition is disposed of.
The notice of the municipality may kindly kept in the record.
Report of the municipality is taken on record.
Grateful, my lord.
Show me the report. This is what you have stated.
But my lord, it is written in Bengali, that's the problem.
Oh.
Well, Mr. Govindas went to the spot on such and such date and
I can't read so much, but I can little bit.
much of them. Henceforth, I shall file English words.
Grateful, my lord.
Question number 8.
Not any time for the petitioner, my lord.
Yes.
But this is a matter, my lord, where my lord, necessary spaces were not left by the private respondent while construction, my lord. But if you my lord, kindly please come to paragraph number 3, my lord.
Yes.
Mandatory space, they didn't leave the mandatory space, and in paragraph number 4, there is a boundary wall which is 8 feet and above.
Yes, Mr. Banerjee.
We have taken instruction, my lord. Hearing has been given. Firstly, here at the time of hearing, they have not attended. Thereafter, hearing was given. Thereafter, we have found that there are deviations, and then we have given a self-demolition notice. Because after the self-demolition notice, police has been intimated. We will take steps for demolition.
I am a private respondent, my lord. Please, the room was purchased my mother-in-law 1973. Old building, my lord.
All
1970.
civil litigation, go wherever you have to go.
No, this is not a new construction, my lord. Old construction. Can you see that?
I only rely on the corporation. All right.
Corporation not properly inspection. My lord, can you see my deed?
Whatever it is, sir. Whatever it is.
For a moment, my mother did and my.
Go to the civil court. So hearing has been done. They are taking action. You are satisfied? I'll record the submission.
Yes, my lord. Consider representation order can be given, my lord.
Sorry?
And if you have a representative or whatever.
Considered.
Now,
Whatever order, my lord.
Old building, my lord, kindly consider, my lord. Kindly.
You
my
take your
deed,
plea somewhere
my
else.
My vendor did kindly
Go
consider.
to the civil court.
My lord. Liberty, my lord.
I don't need to give any liberty. Take down. Learned counsel of the petitioner has preferred the present petition seeking.
The civil court has no jurisdiction.
Wherever he takes his. Why should I
As per
get
177.5, I am saying.
seeking demolition of illegal
They can
construction
come to the High Court again.
that has been carried out by the private respondent over a piece of land situated at 1/2 Ananta Dev Mukherjee Lane, Shibpur, Havra. Full stop. Learned counsel for the respondent corporation or municipality. What is it?
তো বলো বসে বসে কি করছে?
Havra Municipal Corporation. Mr. Banerjee submits that petitioner's representation has already been decided and an opportunity of hearing was granted to the petitioner as well as the private respondent
On 2nd December 2024.
on 2nd December 2024, full stop. After hearing and considering the plea of both the parties, the corporation
Self-demolition notice has been issued.
has issued self-demolition notice in view of the fact that they had come to a finding that unauthorized
On the 100
construction
room, my lord.
exists on the
Challenge করুন না।
above mentioned property. Full stop. In view of such submission made by the counsel for the respondent, the petitioner states that his prayers are satisfied and he shall be satisfied, full stop. In view of this, this court directs that the Havra Municipal Corporation shall bring the said proceedings to its logical end and shall
My lord.
act in accordance with the above direction. The present
to the corporation.
said petition is
Dated, my lord, 20.
disposed of. Sir, do whatever you have to do.
Grateful, my lord.
Item number 9.
Item number I am for the petitioner, my lord. The earlier occasion, your lordship given liberty to serve the notice to the respondent, my afresh, my lord. My lord, it is served 2 times, my lord. It's returned, my lord. One return addressee not located and insufficient address, but other private respondent received the notice from the same address.
I'm not concerned about the private respondent. I'm concerned about the municipality.
My lord. It's an allegation of
Is there any unauthorized construction?
Yes.
Is there any unauthorized construction?
My lord, the prayer was made by the private
And
respondent.
if you have not been able to serve, how do you serve the parties in civil procedure? You have to take steps to serve a party. How do you do it? By publication.
Already, my lord, served upon the 2 private
Sir,
respondents.
if you are not able to serve the third person, how do you serve?
Through jurisdictional police station, my lord, only state is the party.
Do it.
State already party, my lord, through jurisdictional police station, my lord.
You can do it through publication also.
Civil
Yes.
Yes.
I'm completing my lord, it appears that my lord, a prayer by the private respondent was that it was an old building. A portion of that has been purchased, my lord, just money from the common fund.
Sir, what is the status today?
Status, my lord, that the
Do you find any illegal construction there?
private respondent was, my lord, allowed to repair their old and dilapidated.
Private? You file a report.
Yes, my lord.
File a report.
I sir. Since they are, my lord.
This is my instruction.
Bengali
I'm for the
document,
statement.
I can hand over, my lord. It is with me.
No, the
Unfortunately,
very fact that you are saying it's civil in nature. I am only concerned about the unauthorized construction, sir. I'm not getting into the property dispute.
Yes, yes. This is in proper.
At least make that stand clear to this court. Is there any unauthorized construction?
Make myself clear.
Yes.
He is, my lord, that the property was initially belonged to one Shambhuna. Their descendants are there. One brother is there residing at the premises, and other brother has sold a portion of that, and that to my lord to the different area. Is there a vacant land plus another vacant land in which subsequent building came up, according to them.
So
It is there. So it is a, my lord, the dispute was there in so far as partition was concerned or amicable settlement was concerned, it was done, and the dilapidated portion, my lord, came in the share of the private respondent. Then, my lord, it was decided in presence of both the parties in the municipality that the dilapidated portion is allowed to be repaired.
repair and construction are 2 different birds.
Yes. So, my lord, you said.
My lord, kindly see the page number 32, my lord.
Allegation, my lord, practically in my humble submission is of a omnibus in nature. Because from the photographs, nothing depicts. The photograph given in such a manner, your lords will kindly see whether my lord can understand.
Yes, sir.
Yeah, show me the picture. Which picture are you?
My lord, 32, my lord. Annexure P2, my lord.
This building which is shown, the new construction.
New construction, my lord. My lord, can you 32 page number? They are erecting the building.
It's a huge construction.
Huge construction, my lord.
The permission was granted, your lords, can you see? The permission was granted on, my lord, August 20, 2024. Then, my lord, it was even from this, my lord, kindly ask him, my lord, give a full colored photograph, then I can take instruction of that. Because, my lord, from my
File
copy,
a report. Take down.
my copy, nothing transpires.
The present writ petition. The petition has preferred the present writ petition alleging unauthorized construction at 58 Rabindra Sarani, PS Ranaghat, District Nadia, full stop. At the, comma, at the instance of private respondent number 628. Learned counsel for the respondent municipality seeks and is granted 2 weeks time to inspect the said property and submit a report before this court. Full stop. List after 3 weeks.
My lord, on intelligence, my lord, inspection in presence of both the parties, my lord.
Inspection within 2 weeks.
Submit a report within 2 weeks.
Report within 3 weeks.
For the estate, my lord, already.
Inspection and report within 2 weeks. Both.
Estate. Yes.
Matter after 3 weeks.
Great.
I'll just take a break. I'll come in 5 minutes.
Fine.
and a tile shed and a tin shed. Now that was in dilapidated condition, page 19. For the first time, we made representation before the authority in the year 2020 for necessary permission for repairing work of the existing boundary wall. Nothing happened. Then again repetition at page 24 in the year 2021.
Page.
First one is page Maloda, and we come to page 19. That is of 2020. Prayer for allowing a minor repairing work of existing boundary wall and old structure which is in dilapidated condition and may be collapsed at any moment, and there is every chance of. So this is prior to lockdown, 17th of March 2020. Thereafter, we made it again in 2021 at page 24. That also remain unresponded. Now it's completely ruinous condition, my lord. Page 26, that's our last prayer before the authority. Right, 26. It's the 22nd of November 2024. My prayer would be before Lordship, let the municipal authority, the KMC, my lord, take a final decision on this. Let them take a call on this. They remain unrepresented. We are, my lord, in a very bad situation. We cannot stay there. It's entirely ruined. We want to repair and, my lord, I say reconstruct the boundary wall with tin shed or tile shed as would be permitted by them.
Yes. My lord, please come to the page number 24. Annexure P5 of the petitioner, my lord.
Yes.
Second paragraph from the bottom, my lord. That we therefore state before you that due to our residential problems, we intend to make a tile shaded residential house over the said property, my lord. I have inspected the premises. There is no structure. Petitioner, in the name of the repairing, he is asking to construct a new building, my lord. Please come to the KMC Act. $494, my lord. Sorry, my lord, $394. There is provision laid down under the law how to apply for the repairing of the old building.
It's not a building. It's a boundary wall with tile shed. It's not a building.
As per the instruction I have, that one is a vacant land, my lord.
Since 2020, we have been asking for. After 4 years, hardly there is any chance to have anything.
Consider his representation rejected.
Yes.
My lord, please come to the subject portion of the page number 24.
My learned friend is referring to the second one. First one is not.
A tile shed residential structure at premises number so and so. And once again, my lord, please come to the page number 19 of the writ application, my lord. Both subject are separate, my lord. In page number 24, he is asking permission to construct a tile shed residential structure. And in page number 19, allowing a minor repairing, my lord. Both are not saved before the court of law, my lord.
Paragraph 6.
Paragraph 10, page 6.
10. Yes.
They have started to raise construction.
Construction of what?
How they started
Construction of what?
My lord, sorry, my lord.
They have annexed the plan as 35.
Page?
Page 35, they have annexed the right side of the structure. They are going to construct. There was no tile shed. They are not in possession of the land.
But then who are they? There is.
May I allow to submit?
Yes. My lord, in assessment sheet, there is recorded a tile set. But at present, there is no tile set, my lord.
We have been
That's why
fighting- we have
petitioner
been
wants to
fighting
take
for-
the advantage of the assessment sheet. That's why he approached before this writ court, my lord.
Keep your decibel low. I can hear you. So you can decide his representation, you can reject it. What is the
Pardon, my
difficulty?
lord?
You can decide the representation, you can reject it. What is the difficulty?
I am not, being an executive engineer, I am not the competent authority.
The commissioner is the competent authority.
My lord, he has filed the application through portal, my lord.
That's all right.
There is provision under the under section 390, my lord. Petitioner has to follow 399 of KMC Act.
That's a different thing.
He did not follow it.
That's a different thing altogether. You decide his representation, finish it off. Why do you want to keep these things pending? I'll record your submissions, you decide his representation.
My lord, being executive engineer, my lord, I am only abide by the law.
Am I asking you not to abide by the law? You decide the representation, reject
My
it.
lord, my lord.
What is
My
the
lord,
difficulty?
revision order I will pass, my lord. You direct me, I will pass the revision order.
Learned counsel for the present writ petition has been filed seeking consideration of petitioner's application dated 22/11/2024 with a further prayer to construct a tile shed on his residential accommodation. Full stop. It is the contention of the petitioner that he has been making several representations before the respondent authority, but the same has been not acted upon. Full stop. Learned counsel of the petitioner states that his first representation was made on 17/3/2020 and thereafter repeated representations have been made on 7/7/2020, 10/3/2021, 9/8/2021, 22/11/2024 is the last representation
Yes, page
made
26.
by the petitioner. Full stop. Learned counsel for the respondent corporation, Kolkata Municipal Corporation, states that the petitioner has made varying representation, wherein in the representation dated 17/3/2020, he had asked for minor repair work of the existing boundary wall and old structure, which is in dilapidated condition. And in his subsequent representation, he had sought permission for construction of a tile shaded residential structure at premises number Q647/C, SA Farooqui Road, Police Station, Raja Bagan, Calcutta. Full stop. Respondent corporation points out that there is no structure existing at the present site. States that there is no structure existing at the present site. Counsel for the private respondent states
He is not in possession of the land, my lord, and there is no vacant land in
that the petitioner is not in possession of the said property and is being trying to raise illegal structure on the said land. Full stop. Be that it may, learned counsel for the respondent corporation states that they are ready and willing to decide petitioner's representation dated What is the last date of the representation?
22nd November 2024.
22nd November 2024. Full stop. Petitioner states that he shall be satisfied if his representation is decided, representation dated 22/11/2024 is decided in a time-bound manner. Full stop. In view of the statement made by the parties, this court directs the respondent corporation to decide petitioner's representation dated 22/11/2024 within a period of
4 weeks, my lord.
within a period of 6 weeks after granting, within the period of 6 weeks from the date of communication of this order, after granting an opportunity of personal hearing to the petitioner as well as the private respondent or any other interested parties by way of a speaking order. Full stop. With the above direction, the present writ petition stands disposed of.
Highly obliged, my
Our
lord.
petitioner would be at liberty to rely the document at the time of hearing, because assessment and other thing, my lord, I have to place, if your lordship be kind enough to.
That goes without saying.
Great, ma.
Highly obliged, my lord.
Question number 11.
May it please your lordship. My lord, pursuant to your lordship's earlier direction, my lord, I have served upon my learned friend, my lord, for the municipality.
And for the municipality.
My lord, lordship kindly recollects, my lord, this matter, my lord, pertains to, my lord, my allegation against, my lord, the unauthorized construction by the private respondent, my lord, adjacent to my premise, leaving without any site space and also without the sanction plan. So, my lord, I made the representation to that effect, but my lord, the municipal authority, my lord, even did not take any step. So, my lord, compelling, my lord, with that, my lord, I have just come before this honorable court. My lord, the last representation, my lord, that I have made, that your lordship will see, I'm sorry, my lord, it is in Bengali, my lord, it is in page number 22. So, I just beseech your lordship, after I on the earlier occasion, my lord, addressed your lordship that after I filed this writ petition and this copy was served, my lord, the private respondent, my lord, increase the speed of the unauthorized construction or in this meantime. So my request before your lordship, if my learned friends Klein, my lord,
Within 6 weeks, my lord, we will consider representation, giving the adequate hearing to opportunity of hearing to both the parties, my lord.
or in this meantime, my lord, they should at least restrain them because they do not have any sanction plan also.
They'll take action. Whatever action they are supposed to take, they'll take.
There
it.
is no.
Or otherwise, my lord, they
Even
will,
if they build it, it will get demolished.
yes,
Let
my
it
lord
come
has
down
already
to
said that.
more.
My
What
lord
is
has
the
already
difficult?
said that.
Take down. Petitioner has preferred the present writ petition seeking demolition of illegal construction erected at Dag number 301
My lord.
of Moza Karial block Chonditala 2 district Hubli by the private respondents number 7, 8, 9, 10. It is the stand of the petitioner that illegal and unauthorized construction is being carried out by the private respondents without obtaining any valid sanction plan and in total contravention of the rules
My lord.
of the statutory of the rules and bylaws. Full stop. Learned counsel for the respondent corporation municipality appears and states that they shall decide petitioner's representation dated 1st February 2025. Full stop. In view of the statement made by the counsel for the respondent municipality, the petitioner states that he shall be satisfied if his representation dated 1st February 2025 is decided within a time-bound manner. Full stop.
Well, after an inspection at least be done.
In view of the statement made by the counsel for the municipality, this court directs the municipality to decide petitioner's representation dated 1st February 2025 within 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents by way of a speaking order. With the above direction, the present writ petition is.
And also after an inspection, physical inspection, they should do.
That we will do.
How can any action or decision be taken without any physical inspection? How will they pass a speaking order?
Grateful. But the affidavit of service, subsequent affidavit of service will not be kept to the record.
Affidavit service is taken on record.
Grateful. Man.
Item number 12.
एक line. None of the contentions are admitted or denied. वो add करो. ठीक है ना? Without exchange of affidavit. The present writ petition is disposed of without exchange of affidavits.
Item number 12, Mr. Sonat Kumar Roy appearing for the petitioner. Due to some medical emergency, he has not come today.
This week, man.
Not today.
Grateful, Lodge.
When do you want? Next week? Next week?
Yes.
Or tomorrow?
My lord, we'll keep it next week.
Next week.
Private.
Item number 13.
Yes, well, I am for the petition.
I'm for the statement.
I'm for
Well,
the Durgapur Municipal Corporation.
Well, I have filed a representation my lord, for illegal and unauthorized construction my lord, 27 mile. East and western side my lord. Actually, my lord, representation has been filed and no step has been taken up by the Durgapur Municipal Corporation. No, it has not. No, notice has been issued. Person is giving to conclude the hearing.
Firstly, my lord, no steps have been taken. That is, I deny, my lord, because on 5th March, we have made an inspection and we found that a country level has been extended and there is a deviation from the plan which was sanctioned. So we will now make give a hearing and thereafter we'll pass the necessary orders and take steps regarding deviation. মিথ্যা কথা বলা কথা
ওইটুকু পর্যন্ত জানে না ঠিক আছে ভেরি ভালো
But I put the private respondent model, I've constructed the partition of the municipality. There may be some deviation, I'm not really saying so. But let's say we're hearing, opportunity also.
Yes, I will give. I have to. Under 266, there is a provision for hearing. I have only make
for hearing and there's a provision for regularization. Because it's not a
no. Minor deviation can.
Minor deviation.
No, not minor deviation.
All the point we.
And so far as my learned brother has filed a civil suit, that is a bar under section 278.
I'll file a civil suit against the petition.
278, there is a bar.
That is the jurisdiction of the.
I filed a suit against the petitioner for disturbing my.
That is not the
The
jurisdiction.
representation is page 27.
27.
Now we have conducted an inspection that may be noted in the order. March 2025.
But there is no infinite sanction plan.
We are not denying. They have a sanction plan. They have deviated.
Deviation of plan.
There's the allegation that I've constructed without.
Maybe that will be
There is a
considered by the
section-
authority concern.
Petitioner has preferred the present writ petition alleging unauthorized and illegal construction being raised at premises jail number 119 Malta Ringi LR plot number 2260 Khaitan number 14757. Which area? District Paschim Bardhaman. At Paschim Bardhaman.
And Durgapur, Paschim Bardhaman.
Mauja Biringi. LR
District?
plot number 2223.
District?
Paschim Bardhaman.
Paschim Bardhaman, it is at Durgapur block.
District question.
Mauja Viringi, my lord.
Mauja Viringi.
Petitioner states that
They have filed the writ petition in the month of February and we have made an inspection on 5th March.
petitioner
So allegation
states
is
that
vague.
he
Yes,
is
and a plan is there.
the next door neighbor and that an illegal and unauthorized construction is
বলতে হবে আমাকে আমার এটা তো দেখছো
carried out by the private respondent.
মক্কেলে ফেভারে কথা হচ্ছে আবার
Numbers, what are the private respondent numbers?
6 and 7.
Private respondent number 6 and 7. Full stop. Learned counsel for the Durgapur Municipal Corporation
my lord
appears and states that they have conducted an inspection
on 5th March
on
5th March
5th of March 2025 and have found certain deviations in the above alleged unauthorized construction. Full stop. Learned counsel for the private respondent appears and states that they are carrying out the construction in accordance with the sanctioned plan. Full stop. At this stage, learned counsel for the respondent corporation states that they are ready and willing to decide petitioner's representation dated 10/1/2025. Full stop. In view of the statement made by the counsel for the Durgapur Municipal Corporation, the petitioner states that his grievances will stand satisfied if his representation dated 10/1/2025 is decided within a time-bound manner. Full stop. In view of statements made by the parties, this court directs the Durgapur Municipal Corporation to decide petitioner's representation dated 10/1/2025 within a period of 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as
Right.
well as the private respondents by way of a speaking order.
Well,
With the present direction, in view of the above direction, the present writ petition is disposed of.
I'm
grateful.
Item number 14.
14 Lordship, for the petitioner Lordship. Lordship, on the last order, your Lordship has directed to serve again the municipality Lordship. Lordship, it's the matter, I have served the municipality.
Municipality is not a party here.
Not a
Here
party.
also, yes. Same thing is being repeated, but this is the statutory mandate, your lordship would kindly see the act.
Why don't you make municipality a party? Learned
In a
counsel
very
for
true
the-
sense of the matter, this writ petition ought to have been dismissed on that ground, he
counsel
said.
for the petitioner say,
Lordship, I've made
petitioner
a party to
seeks
the
to-
municipality.
Chairman is the party, my lord. 13-2 kindly sees the 13-2
And
of the Municipal Act specific. It's a body corporate.
3 and 4,
Kindly sees.
the
13-2.
board of councillors, the chairman.
That won't do, my lord.
13-2, huh?
13-2, your lordship kindly sees.
It's a matter where the private respondent has been
What is it?
So what is there? This is Calcutta. No, which municipal?
North Barakpur municipality.
West Bengal.
It is governed by the, this is, I have the book. I'm sorry, well, I should have, West Bengal Municipal Act 93.
Make them a party. Petitioner seeks to make the which municipality? North Barakpur municipality.
As a party
to the
respondent.
Present proceeding. Full stop. Seeks leave. Petitioner seeks leave to add Barakpur North Barrackpur Municipality, a party respondent to the present writ petition. Full stop. Liberty is granted to the petitioner to amend the cost right and add Barrackpur Municipality, a party to the present writ petition. Full stop. All right, he'll do that, but now let's come to the merit of it.
The fact of the case is, Lordship, the private respondent has been going on an unauthorized poultry farming over his single-storied house, and I am the petitioner is the next door neighbor house owner. Lordship, in paragraph number 4, I have
for the municipality.
paragraph
Have you
number
inspected the property? Any report?
But firstly, I would say, the private respondent whose name is Shubir Das, he is not running.
He's not?
He is not running.
He's not running.
Running the business.
But
Somebody else is there who ought to have been made a party.
Lordship, in paragraph number 4, I have mentioned what are the precarious situations the petitioner is going through. Lordship, he has a
The license is
and
in the name of somebody
yes, sir,
else.
residential property, the private
তো
respondent has
পরের
got
ব্যাপার, আগে পার্টি
trade
করো
license
ঠিক করে।
in respect of
এটা
the
আছে তো
trade.
trade license।
The house of Subir Das only that poultry farming is going on.
Take down. The petitioner is aggrieved by the inaction of the respondents in not taking any action against the private respondent for running illegal poultry farm from the rooftop of holding number Y1596, ward number 2, Ichapur, Bidhan, Pally near Ankur Club, PS Noipara district, North 24 Parganas. Full stop. Learned counsel, the petitioner submits that due to illegal running of the poultry farm, he is submits that due to illegal running of the poultry farm, there is environmental pollution and it is causing inconvenience to the residents of the locality. Full stop.
Paragraph number
Despite repeated requests, the respondent authorities have taken no steps for removal / shifting of the said poultry farm. Full stop. Learned counsel for the respondent municipality seeks and is granted 2 weeks time to inspect the property and file a report. List after 2 weeks.
The main person in whose name the trade license is ought to have been made a party is not there.
First, do the inspection. These are technical objections, sir. If they are running it, whosoever is running it, you will take action.
Within a period of 2 weeks.
Within a period. After 2 weeks, list it. You make the change right now.
Add করে দে ওখানে। সব বলে দিচ্ছি। He's too new to this.
Item number 15.
Teach him. It's your duty to teach your
Definitely.
younger brother.
Definitely. It's my privilege.
Board of Councillor, some
এটা করবি সব।
My lord, I am suggesting.
Lordship, in this matter, the respondent number 8 to 12 have carried out an unauthorized construction at premises number 12 by 8 by 44. 44, Bedford Lane, Kolkata 16. On the third and fourth floor, the unauthorized construction.
Show me. Show me the report. Report is completely, it's here, nor there, Mr. Naik.
Lord, we have made inspection.
It doesn't matter, is the building sanctioned or not? Where is not even an iota?
My lord, only thing is this. Only thing is this, my lord.
Mr. Nayak, is the building sanctioned or not?
That question was not here, therefore on the.
What do you mean illegal construction? How do you ascertain the illegal construction, Mr. Nayak?
That's it, my lord. I can.
Mr. Nayak,
somebody,
Lordship, I appreciate your lordship.
somebody like you making these kind of,
But lordship, I appreciate, he must mention that when the Another.
no, he need not mention anything, Mr. Naik, please.
Lordship. For the report. Lordship,
Officers like this, they should be sent to jail for filing this kind of a report.
I'll take further instruction and also further report. Very serious issue is involved. Because unauthorized construction, when it started, nothing of this.
It doesn't matter. It doesn't matter, Mr. Naik. What are you saying?
So I'm not defending. I'm simply not accepting what my lord's view is. I will not.
If it is unauthorized, it is unauthorized. Plain and simple.
I will take further.
Corporation doesn't talk like this.
I will not convince them. I will take further.
Petitioner, last respondent, corporation seeks further time of 2 weeks to file a better report. Full stop. उसके पहले लिखो, the corporation has filed a report wherein it has not stated whether the building which has been constructed is without any sanction plan or not. Full stop. This court shows its dismay to see a report being filed by the corporation wherein no particulars of the construction is being mentioned. Full stop. The corporation has failed to even mention if they had sanctioned the construction of the 5-story building which has come up on 12H-12-H-44 Bedford Lane, Ward number 61, Borough 6. Full stop. This court directs the corporation to file a better report since the present one is bereft of any material particulars. Full stop. Mr. Naik seeks further time of 2 weeks to file a report indicating if the present property has been constructed with a valid sanction plan and in compliance with all the necessary regulations. Full stop. He shall further indicate if the said building is not constructed in accordance with the sanction plan, what action has the department taken in furtherance of the illegal construction. Full stop. From next time, I will ask all the executive engineer, assistant engineer, and the junior engineer who have served within this period, initiate disciplinary proceedings against them, ensure they lose their job. Make it very clear to them.
This view is not.
I will do it.
I will do it.
This is my.
Make everybody activate.
Mr. Naik, this is the first day I'm sitting. But I'm making it very clear. I will take it to a logical end.
It may be the need of the day also, because the huge life and everybody.
This unauthorized construction business has to end.
Grateful, Lordship. So, after 2 weeks, Lordship.
Item number 16.
You are there, Mr. Mukherjee, in this?
No, my lord.
None for the petitioner, dismiss in default.
Item number 17.
17, my lord, I am for the petition.
Yes.
And taxes are undue. That is the freedom of bankruptcy.
We are not concerned about taxes. Who are you?
But I don't have to put that to stay at the payment. They get 2012. But I have to do that. For where I have not been given the position. Thereafter, I was told that I will give that is the second floor, and I was told that it is constructed plus two, that is the sanction. That is there in the. Thereafter, I have now found that it is. And now, after they are constructing the six.
What is your interest? What is your interest? You wanted to be a tenant since 2012.
2012.
Where do you live?
I believe as a tenant in I have been outside the. I live
How far is this place from this property?
3 kilometers. But this is a working area and section 450 of the PMCA in a working area. We has to sanction at the customer demonstrating standard layout plan of a bus fee. But we will out of that.
So far as I do not want to say anything so far as the illegal part is concerned, but it appears that it's a Thika property. And prima facie, if it is G+4, it has to be illegal on a 10-foot road. It is abutting by a 10 feet. So it has to be. But the other part is paragraph 7. He has put a flag in this illegal construction. Paragraph 7 of your lordship, we are at page 6. So And this number, wherever your lordship gets,
What is that? That agreement which you are handing over?
the police are
Stated.
You are what? What is your name? Shakib, no?
Now they are.
Yes.
Which we not like. Where even a motor car can pass construction without very poor.
Is there any law?
not want to go into the personal vendetta what he has against the promoter, because your lordship has seen he is a disgruntled would-be purchaser of it. That's one part. But the fact remains that on a 10-foot road, there cannot be G+4 building. Under any circumstances, particularly when the area is, your lordship knows its number, since your lordship is taking up this matter, paragraph 7. P by 4 by H by 2 by 6. Whenever your lordship gets such number in a Calcutta premises, this has to be a basti, because P, the prefix P, denotes a basti.
Okay.
Or it would be a thika. So this number, your lordship keeps it in mind that this denotes a basti or a thika. Well, the one way is subject to what falls from your lordship. Your lordship would direct my executive engineer in name, Projo Kishore, or who is to give a report within 10 days. And what based on that report, your lordship passes an order. Because even I place the law, well, there is no scope of any sort of regularization, because the precondition for regularization is a minor structure. And G+4 without a plan, by no stretch of imagination, can be a minor structure.
But like in Delhi, what had happened is, since these illegal unauthorized construction mushroomed,
yes,
then there's a Special Protection Act which said that the construction which has been done prior to the year 2000, initially the date was 2003, then subsequently it was increased. So all of them will be protected. There's nothing like this here.
I get, yes. 1951 Act, thereafter 1980 Act, so far as Kolkata Municipal Corporation is concerned. Prior to 1951, there is another. 51 Act gives if any illegal construction remains there for 12 years.
Prior to or later?
Prior to
50.
Yes, in 51 Act. 1980 Act doesn't have such provision. 1980 Act doesn't.
So to just, anything constructed prior to 51, there's a protection. 12 years.
Prior to 1980, that is 1951 Act has that provision of 12 years continuing. As on the day, suppose somebody complains there is an illegal construction. They go and see that it is illegal, but on that day, it is found that it is existing prior 12 years prior. So under 51 Act, there is a protection. But 80 Act doesn't provide such protection. And it is, the pictures show, I do not have the colored pictures. My government is fortunate and kept the colored pictures for itself. It shows that.
No, I have it. I have it.
Your Lordship would see that the construction is going on. Even that protection also is not there. I leave it to your Lordship. Directs the executive engineer to give a report in the name of Projokishore God, because your Lordship mentions the name.
My lord, a report has been sent by entirely police station. May I hand up, my lord?
What report is there?
Regarding the dispute, my lord, a GD had been registered, and also, my lord, again, on the basis of the complaint, my lord, an intimation was sent to the executive engineer of the Kolkata Municipal Corporation, seeking to know whether any unauthorized construction. Against the respondent number 10. The parties.
Take down. The petitioner has preferred the present writ petition being aggrieved by the unauthorized construction carried out by private respondent number 13 and 14 at premises number B/4/H/2/6 Convent Lane within police station Entirely, Calcutta. Respondent number 9, construction carried out. Listen to the order, sir. Who's carrying out the unauthorized construction? Respondent numbers?
7. 407, my lord. What number?
Who is carrying it on, sir? Private respondent? Starting from 9. 9, 10. ऊपर वो कर दो, change कर दो. 9, 10. 9, 10. Respondent number 9 and 10. Petitioner contends that he had entered into an, what agreement is this? Agreement to purchase a flat in the said premises in the year in June 2012. Full stop. He states that he was offered a 2-bedroom flat attached with kitchen and bathroom at measuring 300 square feet on the second floor of the newly constructed building. This is premises number is 1B. At the above said premises. Counsel for the petitioner further states that the developer did not hand over the said flat to the petitioner. Full stop. The present writ petition seems to be a private dispute between the petitioner and the developer. The petitioner sat over his right for more than a decade and has preferred the present writ petition alleging unauthorized construction since the developer had failed to hand over the flat to him. Full stop. Without going into the merit of unauthorized construction and the issue of, without going into the issue of unauthorized and illegal construction, this court feels that it is a private dispute between the petitioner and the developer, and the petitioner has preferred the present writ petition in his personal capacity, and it's a personal violation, and the petitioner has failed to point out any public law element, and this court is not inclined to entertain the present writ petition. I know this order will get us set aside, but still take it. I know. Still take it. File an appeal. I know, Mr. Mukherjee.
Wow.
Petition number 18.
Is that matter your lordship recollects where he purchased.
It will come back to me, I know.
That matter.
I know that.
Okay.
Might be so right.
There's your senior. Young junior lawyer, what can I do? Proxy counsel so and so appears and states that the main arguing counsel has left the court due to some personal emergency. He prays for a short adjournment. Let this matter be listed. When do you want? When do you want, Mr.
Tomorrow is the original site day, Madam.
Yes, tomorrow.
On Friday, your lordship.
Friday. Friday.
अपना नाम तो दिया
Item number 19.
Mr. Mukherjee, in the earlier matter, did he make any representation? He has not made any representation.
Which one? He has given certain letters complaining that there is illegal construction going on.
Yes.
I have got the respondent corporation.
Who appears for the petitioner?
For the respondent.
Who appears for the petitioner?
I have instructions regarding entire building is unauthorized.
Entire deal has been done. None for the petitioner.
Only one
Presented petition is dismissed in default.
one thing or liberty may be given to the corporation because there may be a agreement between the two. He is not attending.
What to do?
So only liberty may be given that we will take steps.
Oh, you
I have to.
you
Because
have.
entire building is
I'm not.
unauthorized.
I'm not saying anything. You have to take steps.
As you know.
You don't need my permission.
Sorry. These things are happening. They are filing writ petitions. Now there is a they and withdraws it.
But where you see
My lord, my lord. Right, right. Date.
it has been done.
The written matters have been filed by this petition.
Item number 20.
My lord, I am appearing on behalf of the Chandanagar Municipal Corporation.
My lord, I am appealing for response number 5.
But the matter is by the petition. It is granted by the municipality on the lot of land just can occupied by the regarding the partition and regarding the declaration of title and injunction. In the meantime, my lord, the one of the OCR has made a legal key.
Sir, what are you seeking? Tell me that. Are you seeking mutation?
No, like he is opposing me.
Show me what are you seeking.
Hereafter, a series of complaint has been lost by my client. Not to give the information, it shall be decided.
Show me the order, impugn order. Translate it, sir. Or you read it, I can understand. Read it. So that's all right. What is the difficulty? You have come against this order. All right. All right. The take down. The petition, the present writ petition is challenging the proceedings initiated by the respondent municipality for the mutation of property as mentioned in para 4 of the present writ petition. Full stop. It is the case of the petitioner that he is the co-sharer of the property in question and a title dispute being TS number 176 of 2022 is pending adjudication before the Court of Civil Judge, Junior Division.
Two civil suits are pending, my lord. 173.
Two civil suits are pending. One ke jagah kar dena. Two civil suits are pending. Civil suit number 176 of 2022 and
Lord, 156 of 2018 and 173 of 2022. 156 of 2018 as per the pleading, my lord, in the writ petition. And TS 173 of 2022.
a pending adjudication before the civil court, full stop. Despite the same, the private respondent had applied for mutation of the said plot in her name, full stop. It is submitted by the petitioner that he has already filed his objection. This court has heard the arguments advanced by the counsel for the petitioner as well as the, you appear for?
Respondent number, private respondent, 5.
I am for the Chandanagar Municipal Court.
For the private respondent as well as the Chandanagar Municipal Corporation. Full stop. Since the petitioner is only challenging the notice issued by the Chandanagar Municipal Corporation, wherein no final decision has been arrived at, this court is not inclined to interfere with the present matter at this stage, at this preliminary stage, full stop. The respondent municipal corporation is at liberty to take a final decision after considering the objection of all the concerned parties. Full
My lord,
stop.
one thing, my lord, we have already muted the names of the private respondent.
You have already done that?
Yes, my lord.
Where is the final?
Yes, I have.
Just एक मिनट काटो फिर उसको काटो. The learned counsel for the respondent corporation states that he has already arrived
Granted
at a
mutation.
final decision and the same is not under challenge before this court. Full stop. Challenge that. You challenge that. Learned counsel for the petitioner seeks to withdraw the present writ petition and seeks to withdraw the present writ petition in view of the fact that the corporation has already passed a final order
And mutated the names of the private
same is
respondent.
not under challenge in the present proceedings. He seeks liberty to challenge the same in accordance with law. Full stop. Needless to state, the petitioner is at liberty to challenge the same in accordance with law. The
My
present
lord.
writ petition is dismissed as withdrawn.
My lord, give me the copy of the, my lord, the application.
Why should I, my lord,
They
give
are
it?
not submitted.
Why should I?
Leasing decision has not been.
No, my lord. We have already passed the, my lord, mutation side. Okay, देवे क्या ना?
This court is not RTI.
My lord, some in does it next matter, my lord, item 21.
Yes.
My lord, having some difficulty in the second half, your lordship.
Who appears for the petitioner?
My learned senior counsel, some honorable.
Could it be day after tomorrow, your lordship? Private respondent.
Not today.
Could it day after tomorrow, your lordship?
Highly fix the matter.
Friday, not today.
Friday.
It will come Friday.
Could it be day after tomorrow?
It will be day after tomorrow. Tomorrow is
Oh, I'm sorry.
original
Great.
side matter. Or address of the matters after lunch.
Item number 22.
My lord, I beg your lord, for respondent number 10.
Well, I'm for the respondent number 12 and
We are
14.
for the petitioners. The respondent number 10 is in waiting condition, my lord.
Sorry?
Respondent number 10 is in waiting condition, my lord. My lord, I mean, a senior is required to be appointed as per the instruction, my lord. At first I was appearing in this case. I've been told that senior counsel will be appointed in this particular case, and just because he is in a waiting condition, he could not able to get in touch with the senior advocate, my lord. Can it be fixed on any date after 24th or 25? Because his family members are also being living elsewhere. They are coming, my lord.
What is this case about?
My lord, on the complaint made by the respondent number 10, my counselorship, my lord, was extinguished by an order under 21B. I was disqualified as a counselor. Now, my lord, it is a long drawn litigation, many writ petitions and appeals filed. Today, my lord, here this writ petition survives, where, my lord, the order of disqualification which has been passed is under challenge before your lordships. On 4 or 5 grounds, there is a challenge before your lordships on that order. We are protected by an interim order granted firstly on 20th of January 2023, which is still subsisting till 16th of this month. Now, my lord, page 183, your lordship will find the interim order. The order of removal, the impugned order.
One
183 is the culmination. My lord, the main order starts from page 177, which are ultimately culminated. Yes. Page 177, the main order starts. The operative portion is at page 182 and 183 is the culmination thereof. No, page.
So you have challenged this order?
Yes, my lord. This order is under challenge. Now,
pleadings are complete?
Yes. Way back. Huh? Sorry, no. May I say this? 3 or 4 chances were given to the respondents to file their pleadings. Till date, they have not. So, my lord, now it is to be heard out. Or, my lord, if your lordship is so pleased, I leave it upon your lordships. They have not filed pleadings despite 3 or 4 chances.
Why you have not filed your reply?
None of them.
You appear for the municipality.
And for the respondent number 12 and 14.
12 and 14 is?
They are the councillor of the municipality.
The main respondents are, my lord, the respondent number 10, who is the complainant, and respondent number 9, who is the competent authority who had passed the order. So I have challenged that order.
Who appears for the state?
My lord.
Who's for the state?
But they were appearing. I'll have to check, my lord. Last time none appeared on the behalf of the state. I'll tell you, Lord. First of in the first order where the interim order was granted, then Mr. the learned government leader had appeared, assisted by Mr. Raja Saha and Mr. Debraj Sahu. They had appeared on that occasion.
You don't want to file your reply?
Nobody has filed their opposition.
The thing is, my lord, the respondent 10 is in a very bad condition, my lord. My lord, that is being reason I'm totally handicapped. I'm not getting proper instruction from him. I mean, the things, information what I'm receiving from the family members that they are living elsewhere, they are coming. They will be here by 23-24, my lord. That is being the reason, my lord, I'm submitting. That's I've been told that a senior counsel will also be appointed in this case.
What will the senior counsel do?
Under such situation, my lord,
But you are the advocate on record.
I am the advocate on record, my lord.
So you don't want to file your reply.
I want to file my reply.
Change brief.
File your reply.
Change brief actually, my lord.
I'll give you 1 week time. You file your reply at least. You don't have anything to say in this. You're a performer party.
My my lord answer is very limited.
That's
The
what.
tussle in between 10 and the petitioner.
10 and the 10's complaint, I was removed and by the order of 9.
9 and 10, my lord, you could file exception to this petition or proposition.
This is a very embarrassing situation for me as well.
Learned counsel for the respondent, number 10, seeks and is granted 1 week time to file his. When is the interim order?
My lord, 16th of this month. The 16th of this month. Lord.
My lord. My lord, can it be 2 weeks, my lord? Since the family members will be here and I will be giving all the papers. May it be 2 weeks, my lord. They are coming on 24th. That is for sure, my lord.
2 weeks to file his reply.
Extremely grateful.
My lord, opposition probably will submit to correction. My lord, they are the
Respond number, the state affidavit on opposition. Reply to the same, if any, within 1 week.
1 week, 10 days.
The state is also directed to file their reply. State I, respond number 9.
Number 9. Is the main answer.
The main contesting respondent shall also file their reply affidavit on opposition within 2 weeks. Reply to the same, if any, within 2 weeks thereafter. Though none appears for the state, let a copy of this order be sent to the office of the.
My lord, the state as the advocate who has now been appointed. My lord, we'll have to check up that whether
Let the order be communicated by the counsel for the petitioner to the counsel who was appearing in this matter for the state. All right. Let this matter be listed after 4 weeks. Interim order granted earlier is extended for a period of expires on 16th, right?
Yes, 16th of April.
For a period of 1 month until further order, whichever is earlier.
From date, my lord. From date.
From
or additional
1
period
month from 16th.
All.
16th, expiring on 16th, right? 16th of April.
May I just make one claim, Lord? Probably your lordships have.
Interim order granted till 16th of April is extended further for a period of 1 month or until further order, whichever is earlier, list on.
My lord has, my lord, directed oppositions by the state respondent and 10.
Yes.
My lord, may I be given at least 2 weeks of time because I'll have to deal with 2 affidavits. At least 2 weeks of time, my lord, after they are served.
Then after list 2 weeks and reply, if any, 2 weeks further. And after 4 weeks. After 4 weeks. 30th of April.
Extremely. At most from 16th extended. Grateful enough. ठीक है. 15th of.
Extend होगा 15th of.
Grateful enough.
Item number 23 to 31.
For the resolution from the item number 27 and 28. Then. I'm leaving this.
That in these matters, my lord, in all these matters, an advocate general is made. His representation is required, my lord. He is being represented by a senior standing counsel, Mr. Shishanno Bandyopadhyay.
Why you are not filing a reply?
But,
no affidavit of opposition has been filed.
As per our instruction, predicts was completely.
Of course, it is a point of law.
Still, affidavit in opposition has to be filed, sir, even if it's point of law.
If the state is not filed. My lord,
You appear for the state.
my lord, for the landed advocate general, my lord.
Yes, so file your reply.
My lord, it's for the state advocates, my lord, to file the reply. My lord, I'll take instruction, my lord.
Who appears for the state?
There are some lawyers also appearing for the municipality. There are so many municipalities.
You appear for?
And for the Rajput municipality, lordship, the municipality will follow the guideline of the state. This guideline.
What is this issue?
The issue is the licensed building survey. They are my clients.
Sorry?
My clients are the licensed builder. They are the petitioners. Licensed building surveyors. They work a lot for different municipalities in the state. Now their job is to prepare plans, supervise the construction of the building, and ultimately up to getting the completion certificates from the respective municipality. By certain notification, the state government has restricted our right to the in respect of buildings, restricting the area of construction as well as the height of the buildings. The result is that we are not getting any work. Only in respect of small buildings we can act. Otherwise, we are out of the job. That's the problem, And my stand is my legal point is it's not the simple sentimental issue. My legal point is that the law requires any change we made in regard to these matters to be provided by rules. And how the rules are to be framed, that is also mentioned in the Act. Now here, in issuing these orders, we have amended the rules, executive orders, superseding rules. And even, this has not been, the legal prescription has not been followed. It's a purely legal issue. Now, just to indicate one aspect of the matter, if your lordships kindly take page 156 for this. Page 156. West Bengal Municipal Act 1993 that applies to these municipalities, the various municipalities which are not municipal corporations. Now, under that, the rule was framed in 2007. That rule was amended in 2016. And by subsequent notifications, which are executive orders, that rule or the amended rules has been sought to be superseded, creating restrictions on our rights.
What are you showing?
Page 156. This is an amendment to the 2007 building rules, carried out in 2016. You will also kindly note the date, February 29, 2016. In exercise the power conferred by Section 417 of the West Bengal Municipal Act 1993, the governor is pleased to make after previous publication, as required by subsection 1 of Section 417 of the said Act, the following amendments in the West Bengal Building Rules 2007. Now, kindly turn over to page 158. There is a table. Kindly take serial number 1 and 2 of the table, and kindly see the extreme right-hand column. In regard to licensed building surveyors, number 1 and 2 apply. Here, up to 10 meters, not involving deep foundation or underground structure. This was the area of our operation. We could undertake these constructions. Number 2, from above 10 meters up to 15.5 meters, not involving deep foundation or underground structure. Now, these are licensed building surveyor class 2 and licensed building surveyor class 1 and geotechnical engineer class 2. After that, in respect of still taller buildings, we didn't have those. Now, this gets changed. This gets changed, by page by subsequent order, administrative order at page 191. They went on issuing 3 such administrative orders. One of them I am placing now today, before your lordship. Page 191. Kindly say the governor is pleased hereby to make the following amendments in this department's order number so and so dated 19 February 2020, issued for the purpose of classification of buildings on the basis of any or all of the risk factors. Then amendment. This is an amendment being carried out by an executive order, which really, amends the rule itself. Kindly see the table number 1. Residential building for own use with built-up area up to 400 square meter, up to 10 meter, and up to 6.5 meter, and then storage institution, etc. 6.5 meter up to 10 meters. This is in respect of, kindly see the last column, licensed building surveyors. Therefore, we are restricted in respect of buildings which has a maximum height of 10 meters, starting 6.5 to 10 meters, and with the built-up area is only 400 square meter for own use, and for others 250 square meter only. We cannot construct buildings of the size and dimension as was permitted by the rule itself at page 158. Therefore, the rule gets amended by administrative. And kindly mark this, kindly take page 190. 197. 197. Last but one paragraph. Necessary amendments in the West Bengal Municipal Building Rules 2007 for this purpose will be made accordingly in due course of time. And then says this takes effect from 1/12/2020. Without amending the rule by executive order, they amend the rule and say that the rule will be amended in due course.
You are appearing for whom, sir? Appearing for?
I am not engaged, Mr. Shishanna Bandyopadhyay has been engaged on behalf of Learned Advocate General. He's on his legs, he'll be joining.
Advocate General for the state.
For the Advocate General, because the rules has been challenged.
That's what I'm saying. For the state, right?
State has a separate representation,
Who is happy? Who is state?
Advocate General, since the rule is under challenge, that is why, apart from state, Learned Advocate General is also, the brief is served, upon the Learned Advocate General as well.
That's all right. You file your reply.
Siddiqui is appearing on state.
Who is
No,
Mr. Rai, who do you appear for?
no, I'm Mr. Gupta, my lord. I've filed my reply.
Yes,
Sorry, man, I was.
File your reply.
Siddiqui is appearing on the state.
As a matter of fact, no provision of any law, of any act or rule has been challenged. Only the executive orders are under challenge before you. If your lordship can take the prayers at page 57. Iris have any?
Just a minute.
কষ্ট করে এই জি রাখা হয় না আচ্ছা বুঝতে পেরেছি ভাইরাসটা আছে বলে এই জি আছে অর্ডারের বাইরে আল্ট্রা ভাইরাস টু আর্টিকেল 14 দিন ধরে আসছে হচ্ছে ইনস্ট্রাকশন নিয়ে
What is this order, this order of Justice Sinha?
Justice Sinha's order, my lord, is the dated job. Justice Umrida Sinha.
16 February. 16 February 2023.
There are two orders, no? One after the other.
What is this final judgment which has been pronounced by her on 16/2? What is this judgment which has been pronounced? What is the subject matter in that writ petition?
Well, only the executive orders are unnecessary. There is no order passed by the authority separately for us.
No, in this writ petition 2131.
Yes.
16 February 2023 order.
16 February 2023 order was passed
2023 order.
at the interim stage.
There are two successive interim orders, my lord, on two successive dates. The interim orders were passed. The first one was on 16th of February 2023. Shall I hand up, my lord? It will be in the record.
আছে আমার কাছে
Despite several opportunities, no affidavit in opposition has been filed by the respondents. The respondent, Mr. So and so, appears on behalf of the Learned Advocate General and seeks how much time?
but 3 weeks will not be fine
3 weeks time to file his affidavit in opposition. Respondent, you want to file your affidavit?
I will follow the state. Not the means where I will follow the guidelines of them.
File his affidavit in opposition. Full stop. Reply to the same, if any, within how much time? 2 weeks thereafter?
1 week, 1 week.
In 2 weeks thereafter, list after 5 weeks.
Interim order. Interim order we extend the interim order.
Then the matter possibly will go beyond the vacation.
No, sorry?
The matter possibly will go beyond the vacation after 3 weeks.
Yes. Interim order.
The
Vacation starts. Interim order is there till 3 months.
Kindly extend the interim order.
It's already extended, sir. Your interim order is till when?
Still valid. It's for
4 months. It's still. It's already 3 months. Much beyond.
Thanks.
Item number 32.
My lord, item number 32, my lord, I am for the petition.
Well, I am for the respondent of 4 and 5.
I copy 31 identically. 25, 23 to 31.
You have made him a party now?
My lord, I have, pursuant to the order of the court, my lord, I have given a notice to the Municipal Service Commission that says.
Have you made him a party, sir?
My lord, to obtain his address, my lord, I have given to the appointing authority. They have received, my lord. Long back, they have not given reply. The learned advocate appearing for the service
Not
commission.
here to fish in for your replies. Learned counsel for the petitioner has not complied with the earlier direction of this court by making the respondent Mr. So-and-so a party, whatever a party to the present proceeding. He seeks, how much time you want?
My lord, 3 weeks time.
He seeks 4 weeks time to make so-and-so a party. Let this matter be listed after 4 weeks.
I am for the 4 and 5, respondent of 4 and 5.
Oh, naam likho, Charanjit.
Start. Item number 33.
Please, your lord.
But the petitioner is a decade old.
No chance to agree for argue for 4 days.
My lord,
Yes.
the petitioner is a decade old hotelier. But up to 2018, 2019, trade license was renewed by the Howrah Municipal Corporation.
Yes.
Thereafter, my lord, COVID intervened. We applied for, my lord, for every year, but nothing was done.
Yes.
Last, my lord, we made a representation in order to ascertain what the fate of my application for renewal of the trade license. They kept silent. Then I moved the writ application with notice to the, upon notice to the respondent. Then, my lord, the petitioner was called upon and intimated that in the website, the reason was given. Then, my lord, with the leave of this honorable court, I filed supplementary affidavit.
Yes.
And it appears, my lord, that corporation have imposed, my lord, an enormous tax for renewal of the trade license. Now, my lord, the Justice Chondo, when I moved the application, asked the respondent to file report to justify the imposition of tax. My lord, a report was submitted, but still Justice Chondo was not satisfied, and my lord requires further hearing. But if you will kindly take trouble to look at, my lord, page.
Yes.
21. My lord, page 14 onwards. That's the renewal, my lord, from year to year. Your lordship will find, my lord, the first column for enlistment, that's a trade license, 500 rupees. For eating house, 5,000, and other cost was imposed. Then, my lord, next, my lord,
yes,
for 2015, 2018, 2015, 2016, your lordship will find these are the, my lord, the fees imposed
for renewal of the trade license.
Yes.
It was renewed, my lord. Next, my lord, 2016, 2017. Same charge. 2017, 2018. Same charge.
Not same. Increase.
5,000.
Increase, sir.
5,000.
Increase.
Yes.
Charge increased.
My lord.
Not same.
Renewal charge, my lord, enlistment 500. Others charge imposition, my lord, 3,000, 35,500. Next, my lord, 2018, 2019, your lordship will find 1,000 was increased.
Yes.
36,500.
Yes.
Now, suddenly, my lord, thereafter, when we filed the application for renewal, it was not heeded, my lord. Then in the supplementary affidavit, I filed, my lord, the tax imposed for renewal that your lordship will find, my lord, my supplementary affidavit, page 5. এটা কত বলছে? 12 lakh.
12 lakhs 96.
12 lakhs 96,000.
2019-20 charge course 2021
These are the periods, my lord, when we applied for renewal of the trade license. They did not renew, did not give any reply. And these are the, my lord, tax imposed. Kindly look at, my lord, 2019, 2020, 25,000. 2 lakhs 59,000. 2 lakhs 59,000. 2 lakhs 59,000. And my lord added 12 lakhs 96,000. My lord, my first submission would be, my lord, if your lordship kindly take trouble to look at the order passed by Justice Chandra, my lord, a report was called for and report was submitted. And that report, my lord?
I don't have any report.
No, report was
Must be in file, my lord. How a municipal corporation, my lord, filed the report? Right, na?
Any report?
Report was at that
I
point
don't
of
see any
time,
report.
not from that point of not submitted. Honorable Court directed me to come with instructions and the report, if any. And I have instructions that as per law, and they also know very well, as it is a 138 room hotel. As per law, they have to be charged what they have to be charged. It is exactly that. They know very well. Now, my lord, they have come to my learned senior because my senior can reduce it. In any manner, I can place, my lord, the regulations, my lord. So far as the regulations is concerned. If your lordship gives me time, I can file affidavit at length.
Yeah,
Otherwise, I will place the regulations. In regulations, rupees 3 per square feet is the build up.
That will not help, Mr. Banerjee. You have to file the.
I have to file a detailed affidavit. That is required, my lord, your lordship. Because they know everything, but still.
I know everything. What?
Regulations তো স্যার আপনি জানেন জেনেও আমাকে বলছিলেন না তারপর আমি যখন বার করলাম তখন এবারে চুপ করে আছেন
Do they have a branch in Shantigeneketan also?
In this hot
138 number of rooms. Shantigeneketan বাড়ি আছে নাকি স্যার? I have also one small. For that reason, I am asking whether.
It's always there.
In all over West Bengal here.
No, Shantiniketan. He loves Shantiniketan.
স্যার আছে আমারও তো আছে
A small heart.
He's got a very
Not
nice,
small heart, my lord.
very nice house there. Mr. Sandeepan Banerjee appears for the municipality and seeks is granted.
But only by submission, your lordship will peruse the report, they submitted.
Sir, there's no report here.
Your lordship is not. Man, may I hand up? Copy was given to me, I have the docs.
Let him file his affidavit in opposition. That will not help me. I'm not
detail
expert in arithmetics.
And last order, your lordship will find 18 March.
Let him file his affidavit. 4 weeks time to file his affidavit in opposition. Reply to
My
the
lord.
same if any within 2 weeks thereafter. List after 6 weeks. Six.
My lord, 2 weeks.
6 weeks, 4 weeks.
4 weeks. Returnable 4 weeks.
No, returnable 6 weeks. After
Returnable-
6 weeks. 4 weeks affidavit in opposition, 2 weeks reply.
Thereafter for hearing, liberty to mention.
My lord, may I claim one regulations, my lord?
Yes.
We don't fix the date, my lord. 14 May.
Sir, ছুটির আগে hearing করবেন?
He would have gone to Shantiniketan by then.
ওই সময় তো শান্তিনিকেতন যাবেন। স্যার বলেছেন। আপনার সঙ্গে দেখা হবে এবার। Grateful, man.
I am appearing for the municipality, respondent municipality, Lordship.
My lord, I represent the private respondents, numbers 5 and 6. Keep this aside.
What is this? The report?
Yes, my lord.
You have
Yes, my lord.
My lord, in this report.
copy has been given to them?
Copy has been given, my lord. My lord, the
Objection?
objection, I will file the objection on the next date, my lord. Kindly, my lord.
My lord, may I point one
Who are
thing?
you appearing, Mr. Lavani?
My lord, I am for respondents numbers 5 and 6. Now, my lord, respondent number 5 is the landowner. Respondent number 6 is the developer who's.
Lakhwani, you were there at the inspection.
My lord,
No, my
the
lord.
sanction plan was never provided to us, even while the measurement was going on. And even after the measurement was done, sanction plan was never showed to us. My lord, and the second thing is, my lord, I personally went over there and saw the sanction
Saw
plan.
the petitioner.
Yes, my lord.
Where
I'm
do you
for the
live?
petitioner. My lord,
Where do you live?
where do you live? I live in Hubli.
No, near the property?
Yes, for the petitioner. Bhadrashwar Municipal.
Neighbor.
File your reply to this.
My lord, actually, the measurement.
File your objections.
May I just point out?
Disputing everything. I am the municipality. We have also given a report. We have measured. They have disputed this. So they asked for the appointment of special officer. Now special officer has gone. He has measured. His report says that there is no deviation. He wants to dispute.
My lord, that all this was done without giving us the sanction plan. And I personally saw the sanction plan. They didn't give us any copy. I saw there was.
You are not supposed to get the sanction plan.
My lord,
You are
that's
not supposed
My lord.
to get the sanction plan. Do
My
you
lord.
get that?
My lord, but that shall be, my lord, and violation of natural justice, my lord.
Not at all. Not at all.
My lord, one thing, my lord, I personally saw the sanction plan. They didn't allow me to take any photocopy, but there was no
My lord, a
specific
title dispute has been
mention
raised,
of
my lord, in a
the
writ petition.
statutory gap, my lord. There
Suit
was no
pending.
mention of the gap.
Suit pending.
There was no mention of the gap, my lord. I saw the sanction plan personally. And if the respondent can show there is a mention of sanction statutory gap in the sanction plan, I will leave the court.
There is no contrary view between the report here and your report.
Right?
Same.
They want a second special officer to.
And my lord, another thing, my lord, I want to mention in the previous measurement, my lord, dated 31st August 2023, it was stated that it was a commercial building, and the statutory space which is over there, it is not according to the commercial building, my lord. It is according to the residential. Kindly come to section 50, rule 50 of the West Bengal municipal rules.
What are you showing? The first show from the document.
My lord.
You are the neighbor.
Yeah, my lord.
Relative, my lord, common property partitioned many years ago,
My lord,
and
kindly
now
come
when
to
we are
page number
constructing.
88.
My lord, may I just give the basic facts?
It is mentioned that it is
tell me.
commercial.
My lord, two sisters owned the property which they inherited from their father. The petitioner is my wife's sister. My wife is now widowed, my lord, dead. So, my lord, I am now the owner of the property. So me and my sister-in-law, my lord, own the property, which is partitioned. There's a partition in between. Now I constructed on my portion having a sanction plan. They filed a writ alleging violation, my lord, of construction rules and alleging that either there is no sanction plan or in the alternative, the construction is bereft of a sanction plan. So they came in a writ. Usual order was passed directing the corporation to give both parties an opportunity of hearing, conduct a survey and give a detailed report. Detailed report was filed. They were disputing. They said, no, the inspection must be done in the presence of their surveyor. So, my lord, inspection was done in the presence of their surveyor and our surveyor. Transparently inspection done. Final report passed by the corporation saying not an inch has been deviated. On the contrary, they have encroached a part of my land, which is subject matter of a civil suit. They come in a second writ petition challenging that final order of, my lord, the corporation. My lord, I objected to the maintainability. Nonetheless, the judge was of the view that since they are making an allegation, let me appoint some honest officer of the court, a lawyer who will go and, with the help of a surveyor, verify if the corporation's report is correct or not. That report has been filed, my lord, is just saying the same thing. So twice over, once by the corporation, once by an independent advocate appointed by the court, my lord, inspection has been done. And the finding is that not an inch has been deviated and the construction is exactly as per the sanction plan.
My lord, according
So,
to
my
the
lord, where is the question of, my lord, this writ continuing any further?
I'm led by Mr. Nayak.
And I'll show lordship pleadings in the writ petition. They are raising title disputes that the partition.
Just show me the document.
My lord, kindly take the writ petition and see page 88. That is the final order which they have challenged in this writ petition. Page 88, your lordship will see there, my lord, the bullet points there that a G+3 storied commercial building plan.
Just a minute. Yes.
Yes, my lord, page 88. My lord, those bullet points there, if your lordship sees that a G+3 storied commercial building plan sanctioned against defendant on dated so and so. The property of the petitioner situation is the side of the defendant, that after the thoroughly measurement of land of both the parties, petitioner and defendant, it is found that ongoing construction of the defendant in western side of petitioner, leaving so and so space in the back and so middle from the property of the petitioner, that the height of boundary wall of the petitioner is not as per so and encroach some portion of the land of the defendant. So they are the petitioners. And the finding is that they have encroached my land and they are, my lord, raising a boundary. There's no finding against me. And then your lordship will, my lord, turn over to the next page. My lord, next page, kindly turn over to page 89. Some portion of boundary wall of petitioner situated in the property of the defendant. So, my lord, I am the victim here as per this report. And some portion of existing construction of petitioner encroached in the property of the defendant. So all findings are against them in their own writ petition, pursuant to their own writ petition. That the height of the boundary wall of the petitioner is not.
See the first round of litigation order.
And the first order, my lord, is at page 77. Up to page 79, my lord.
Yes.
This is a standard order, my lord, that a usual litigant, my lord, gets, which is an innocuous order. Pursuant to this order, an inspection was done, survey was done. They objected, saying their surveyor wasn't present. Then again, my lord, the corporation obliged them and my lord called for their surveyor, and in the presence of their surveyor, my lord, again inspection was done. Final report filed, which is my lord at page 88, where the finding is that my lord they have encroached, not me. And then they challenged this, my lord, in the writ petition. My lord, the learned judge, my lord, in all fairness, my lord, in his magnanimity, appoints another person to, my lord, cross-check and verify if the corporation has done a clean job or not. And he's also, my lord, now filed a report saying that everything was as per the plan, insofar as my construction is concerned. And a civil suit is pending, my lord. Admittedly, civil suit is pending. There's a title dispute between the parties, whether the line in between the two properties is correctly drawn or not, as per the partition. That, my lord, can't be adjudicated by the writ court.
Yes.
Subject to correction.
Mr. Nayak.
My lord, issue is very small. Whether, my lord, building has been constructed as commercial building has been constructed as per the provisions of law or not. That is to be looked into. Now, my lord, so far as this plan is concerned, my lord, it is not maintained because the mandatory open space has not been maintained. That is prevailing, my lord, in the record, in the report, everywhere. Show me. Lordship. 4 feet mandatory distance maintain coordinator. And also, my lord, the plan.
Show me, Mr. Nayak, before you make any statement, please show me from the document.
Lordship. Page 86. Below page 86, please, Lordship, kindly come. Page 86. And also at the same time, my lord, the report of the special.
Nothing is there on page 86. Mr. Nayak, please make submission as per record.
86, Lordship, page 86.
86 is what? Nothing.
13 No, no.
We are not getting into it, Mr. Nayak.
Distance.
86 is nothing, Mr. Nayak. What is there in 86?
That's the, my lord. That's
Please,
the, my lord.
sorry. Come, any observation from the municipality? Show me there.
Lordship, kindly come to, my lord, the special officer report at page 13. Kindly see that.
Page?
13. Page 13.
13.
Yes.
Page 13?
Special officer's report, Lordship.
Special.
Yes. Mandatory space for
Yes.
4 meter. Now, my lord, mandatory space as per law, my lord, is to 4 meter. My lord, now it is said, my lord, kindly see the leave space only 5 feet.
And 4 feet.
5 feet and 4 feet. In between, Lordship, kindly see the report. Instead of, my lord, 4 meter, that means 4 into 3, 12, around 12 feet. What is the open space left?
I don't understand.
Here, my lord, it is in one side. It 4 feet 2. 4 feet 2 inch. 4 feet 2 inch in the bottom side. And, my lord, and rest of the portion has not been, my lord, mentioned different. In fact, 4 meter has not been maintained. Only, my lord, 4.2 inch. 4 meter, 4.22 2 inch. 4 feet 2 inch. 4 meter. And it is admittedly, my lord, it is commercial building plan. And sanction plan has not been, my lord, shown to us. Even we have not seen this. Let the plan be produced, a copy be given to us, we shall at our cost. And, my lord, verification may kindly be made.
Take down. This is the second round of litigation. The petitioner has challenged the order dated 31/8/2023.
May I have one minute indulgence, Lordship? 1 minute indulgence, Lordship. Law demands, my lord, 4 meter. And, my lord, the report commercial. And the report is showing only 4.2. And this is, my lord, here is annex law is also annexed here, Lordship. Section 50 of the Municipal Act.
Sir, Banerjee, you have seen both the reports. No illegalities. No illegality.
As per the report, there is no illegality.
This is the second round of litigation. Petitioner has preferred the present writ petition. पहले से कर लो. Petitioner has preferred the present writ petition, seeking recall and setting aside of the order dated 31/8/2023.
এটা আছে হ্যাঁ স্পেশাল অফিসার রিপোর্ট ঠিক স্পেশাল অফিসার রিপোর্ট অ্যানেক্সার
Petitioner is
বিল্ডিং রুলটা কোথায়
petitioner had filed a writ petition
তাহলে এটা তুমি দেখাচ্ছ
WPA number 5688 of 2023
রুলটা দেখাও না বিল্ডিং রুলটা
alleging
বার করো
unauthorized and illegal construction
আমরা তো
being carried out without leaving mandatory side open space and without a valid sanction plan against respond number 456.
ওইটা আনবে তো
Full stop.
আমাকে বলবে সেটা
The Honorable Court in writ petition number 5688 of 2023, wide order dated 1/5/2023, had given direction to the Champadani municipality to consider and dispose of the representation made by the petitioner after affording an opportunity of hearing to all the necessary parties, including the petitioner, within a period of 3 months. In view of the said order, the respondent corporation had passed an order dated 31/8/2023, wherein, after affording an opportunity of personal hearing to the petitioner as well as the other respondents, and after conducting
joint survey, no? Joint survey.
inspection and with the aid and help of a surveyor deputed by the petitioner, the municipality had come to a finding had submitted the following report. यहाँ से ले लेना, यहाँ से following report, page 88 to 89. From the said order, it is apparent that the construction was made as per plan and according to building rules of West Bengal Municipal Act. Full stop.
But not as per 50, rule 50.
Being aggrieved by the said order, the petitioner has challenged the same in the present proceedings. Full stop. This court in the present proceeding, while order dated 3/3/2025, had appointed a special commissioner, Mr. Raja Ghosh, who along with a qualified surveyor was assigned the task of determining whether the mandatory side and rear open space have been maintained by the private respondents 5 and 6 in the construction of the building in dispute, and whether there is any deviation from the sanction plan. Full stop. Even in the second round of litigation, a report has been filed by the special commissioner, Mr. Ghosh, who has indicated in his report that the building is in conformity with the sanction plan and there is no encroachment and there is no illegality in the said construction. Full stop. In view of
the earlier order passed wherein the petitioner was granted the liberty to appoint a surveyor, and despite availing the opportunity of hearing along with the surveyor's report, the Champadani municipality had come to a finding that there was no illegality in the said construction. Rather, an observation was made that the petitioner has encroached upon the respondent's property, as well as the boundary wall of the petitioner was not in accordance with the building rules. Full stop. Without getting into the inter se dispute between the parties, this court has gone through the report filed by the special commissioner, wherein the exercise of ascertaining the legality and violations were taken up on a taken up again, were taken up twice, full stop. And similar finding has been arrived at by an independent special commissioner, wherein no illegality has been found.
My lord,
In view of the order passed by the corporation, as well as the report submitted by the independent commissioner, nothing survives in the present writ petition, since the finding of both are clear to the effect that no illegality sustains in the present building, and the same is in accordance with the building bylaws.
But before closing, Lordship,
The present writ petition is dismissed.
Lordship, kindly appreciate one thing, Rule 50, violation of Rule
I have
50.
taken appeal. That is the
No,
reason.
it is not mentioned anywhere because the report, the commissioner has not mentioned, my lord, instead of 4 meter, it is stated that 4.2 feet.
It's all right.
What is the answer by the municipality?
Mr. Naik,
Law says, my lord, commercial building 4 meter distance has to be maintained. Now report says 4.2 feet. Then where is that? Where is that,
copy
my
of
lord?
the report is taken on record.
Where is that, my lord? Answer. My lord, one indulgence, may I pray?
Mr. Nayak, I have expressed my opinion. I'm
Only-
not the last court.
No.
Am I the last court?
No. Why shall I not? Why shall I not rely upon your lordship of the
Mr.
vision?
Nayak,
Only one indulgence.
I have dictated my order. You please take it in appeal.
One indulgence, may I take, lordship?
Mr. Nayak,
Report has come.
yes.
Lord, may we have an opportunity to put an exception to the report only, without closing it. Let us have this
Before you
opportunity.
started the argument, Mr. Nayak, you should have sought that exception.
My junior did it, my lord, in the midst, I have come.
He did.
I
he
pay
did.
this indulgence,
Just
my
take
lord.
down.
Only, my lord,
After
exception.
dictating the order, Mr. Nayak seeks liberty to file an exception
To this report, because
the
report has not dealt with
This
this.
court does not feel that it is fair that after wasting the time of the court for almost 45 minutes, Mr. Nayak,
My lord, kindly accept.
after dictation of the order, decides and seeks liberty. This court is not inclined to grant him this liberty. The present writ petition is dismissed.
My lord, only one line can be mentioned, lordship. Why?
No line, Mr. Nayak.
Remuneration of the surveyor.
Sorry?
Remuneration of surveyor.
Sorry?
Remuneration
Of surveyor.
not
You
paid.
didn't pay.
I'm paid. But
You get paid? You got paid?
paid my
He is the special officer. He has been paid, but he has engaged a surveyor. He's asking for remuneration of the surveyor.
not paid.
Why you have not paid?
There is no
I-
direction.
I do not know, my lord. There was a observation that survey needs to be paid by him to the commissioner. It isn't paid. What commissioner will needs, my lord, that was not clarified. If my lord should desire, that is different issue. But my lord direction, commissioner,
Pay
pay
the
remuneration.
surveyor, Mr. Nayak, pay the surveyor. How much is the amount?
There is no direction.
2000 crore to warrant.
Mr. Nayak undertakes to pay rupees 2,000 to the
There's no direction that he will hire somebody and we shall make them. That was no
There
observation.
is no observation. in the
No,
order.
no observation. So why asking that, my lord, from his own?
50,000 is the fixed amount.
That was his. It was not required to be done. Our image is also a question. If you say I am bound, I am grateful, lordship.
Number 35.
But I appeal for the concerned municipality.
Commissioner doesn't want to proceed with the matter and hence praying for the withdrawal.
You are the advocate on record.
Yes, ma'am.
Petitioner does not wish to press the present writ petition. The same is dismissed as not pressed. Unauthorized construction or?
Yes.
Wait. Give me the file.
I filed it.
Wait. Why you don't want to press this writ petition?
Parties arrived at settlement.
What settlement? How can there be any settlement in unauthorized construction, madam?
I am not aware.
How can you settle a matter in unauthorized construction? I'll send you to jail.
My lord,
I'll send you to jail. Where's the petitioner? You call the petition person. I'll send him to jail from here. What settlement you're talking about? Is this a forum to settle matters in unauthorized construction? Are you an extortionist? How can you settle the matter?
but I have the only instruction that to withdraw.
I'll impose cost upon you. Where's the petitioner?
He's not here.
You are the advocate on record?
Yes, madam.
Madam, I am warning you. As a young counsel, you should not be filing this kind of petitions. Don't allow your office to be used in this manner.
Okay, madam.
Please be careful. You're officer of the court first.
Letter has
You can't allow these people to extort money and be a part of this chain.
Sorry, my lord.
Dismissed as withdrawn. Just because you're a young counsel, I'm leaving it.
Without the other.
Item number 36.
But I appeal for
for the
the
petition.
municipal, concerned municipality.
This is my affidavit of service, my lord.
Number 8.
It will be. My lord, petitioner is the owner of the land, my lord. The private respondent, who is the adjacent to the property, my lord. He started construction without obtaining any permission from the municipality, my lord. So, my lord, the petitioner made a representation. Kindly come to the annexure P2, my lord, page 14, my lord. Regarding my lord.
Just a minute.
Sorry, my lord.
Annexure P2.
P2, my lord. Page 14, my lord.
Yes.
That was duly received, but till date they have not taken any steps to consider my objection or representation, my lord.
2 years old.
No, I tell your lordship. But I tried to take instructions. For what I have received, I'll hand it to your lordship. But I find that, my lord, on 3 occasions, hearing was called for by the municipality concerned of both the petitioners and the petitioner and the private respondent. But either one day one appears, the other is absent, the other appears, the other is absent. Ultimately, since on none of the days the both were present, my lord, the municipality has disposed of the application, saying dismissed. Your lordship, once again.
What is the order which has been passed?
No, that is what I was submitting, my lord. The municipality simply says, I am not satisfied with this. Municipality simply says, since none of them have turned up on either of the occasions,
no way.
I am not satisfied with that. So it should have been done, kindly fixes a date when both of them will
Yes,
appear.
Your
Because
lordship
they have
said that
either or the other
must
is not
be
to appear.
present, my lord. Petitioner must be present, my lord. Your
I will not be
lordship said
placing
that, my lord.
that this is the order. It should be done. Something should have been arrived at.
Petitioner has preferred the present writ petition, seeking demolition of unauthorized and illegal construction at holding number 172, ward number 17, South Dum Municipality. Petitioner contends that he has made a representation dated 4/12/2023 before the
South Dum Municipality. Full stop. Learned counsel for the respondent municipality states that in terms of the representation dated 4/12/2023, the petitioner was called You are alleging unauthorized construction of holding number 31/1.
Yes, my lord. Construction number, yes, my lord.
Why do you write different?
Holding number, my lord, no, my lord. Holding number, my lord, 72, my lord. Holding number 172.
Here it's 31/1.
My lord, kindly see the representation, my lord. Holding being number, my lord, 172, my lord. In representation also mentioned, my lord, in prayer person also.
May I just have a look at that instruction I handed over to your lordship?
That's the reason. The property number is 31/1.
Because the notice also gives the same number, which is not telling from here.
It's not telling.
Not telling. Because he says 172 ward number 17, this says 31/1.
No.
My lord, in my representation, my lord, the holding number 172, ward number 17, South Dum Municipality, my lord.
Ward number 17.
Page 14, my lord.
Well, may I make a submission subject to what falls from your lordship?
Sorry?
Well, may I make a submission subject to what
Yes,
falls
yes,
from your
please
lordship?
tell me.
My lord, this representation at page 14, which your lordship has just seen.
Yes.
My lord, even if my lord the telling number was tallying, my lord, I was submitting, I was not satisfied with this because this cannot be a order by municipality wherein the alleged authorization. Kindly directs us to my lord do this de novo, fixes a date where then both should appear.
Yes, my lord. I will page in my lord.
Calico. In terms of the representation, in terms of the representation, the petitioner was
phone number
was called for a hearing. But he never appeared. He never appeared.
That no, one day he appeared. There are three orders. Kindly see.
No, both parties are found absent. First order.
First order.
Second order, the complainant is found absent. Third order, complainant is found absent. He never appeared.
He never appeared. At least in this hearing. No, this premises number.
The complainant had not appeared before the municipality. A copy of the hearing conducted on 28/2025, 17/2/2025, and 28/2/2025 is handed over to this court, which is kept on record. Full stop. Learned counsel for the petitioner states that he was never served with the notice of hearing. Be that it may, the respondent municipality is ready and willing to decide the representation dated 4/12/2023. Full stop. In view of the said statement, learned counsel for the petitioner states that his grievance shall be satisfied and he does not wish to press the present writ petition if his representation dated 4/12/2023 is decided within a time-bound manner, preferably within a period of 6 weeks from the date of communication of this order. Within a period of, in a time-bound manner, full stop. In view of the statement made by the parties, this court accordingly directs the respondent municipality to decide the representation of the petitioner dated 4/12/2023 within a period of 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondent or any other interested party by way of a speaking order. With the above direction, the present writ petition is disposed of.
Deeply
You
Deeply
keep this on record.
Affidavit of service taken.
Question number 37.
Sir, I am appealing the petitioner. On last occasion, Your Lord, the Honorable Court was directed to file report in the form of affidavit, both the
So I am appealing for the corporation.
corporation and the
My lord, I am taking for not this week to file the report, my lord. Kindly keep it on next,
You were given time, madam. State was granted time to file report.
I called the officer, my lord, but my lord, due to his personal difficulties, because his mother is admitted in.
Only one person works in your corporation.
My lord,
No, corporation.
I am a state.
my lord.
Only one person works in the state.
My lord,
Only one person works.
no, like there is junior, my lord.
So, report can't be filed.
So, my lord, BLRO is the authority, my lord, to file a report, my lord.
So,
Because there is some dispute, my lord, regarding the record of of the land, my lord, nature of the land, my lord. My lord, in the RTI, my lord, the report has given that as Danga, my lord, but from the other information, it has come to that it is Doba, my lord.
what is the order which has been under challenge?
Lordship order is passed by the, Lordship, kindly come to page 44. The order passed by the Commissioner, Chandanagar Municipal Corporation. And I have challenged it as they did not call the record from the BLRO at the time of hearing. And Lordship, kindly come to page 48. The report I have sought from the RTI Act, from the BLRO, Revenue Officer has stated that the RS plot number 26 and
You
Pillar
applied for the
plot number-
corporation?
Yes.
You have filed your report?
Yes, I have done. But it indicates that
Lordship, I have to
Lordship,
file the
whatever
exception in this.
it is supported by the documents maintained by the Department of Land.
Take down. Learned counsel for the state seeks further time of 3 weeks to file her report. Exception to the same within 2 weeks thereafter.
Lordship.
Full stop. Learned counsel for the municipality, respond number 4, 5, 6, and 7 has filed his report.
Copy served upon the petition.
Lordship.
I served the copy of the
Report and a copy of the same has been served upon the petitioner. Full stop. Petitioner seeks 2 weeks to file exception to the same. Let this matter be listed after 5 weeks.
Lordship, interim order earlier granted be extended.
Interim order granted earlier. Interim order granted earlier shall continue further for a period of. When is this expiring? When was the first interim order given?
First interim order was given.
It's already expired. Sir, when was the first order passed?
Lordship, I am keeping. It was passed on 7th October 2024.
Right. And the next order?
17th December 2024.
By that order was already over. It's already or has expired.
So it was in the list. Or
the order dated this court-wide order dated 7/10/2024 had stayed the operation of the order dated 4 July 2023 for a period of 3 months. Full stop. The order was extended on 17/12/2024 for another 3 months. Full stop. So the same has expired. This court grants an interim order of stay against the operation of the order dated July 4, 2023 for a period of 3 months from the date of passing of this order. Yes.
As per the last order, we have been served with an opposition last Friday. But I need a week's time to not come back with the rejoinder. But,
Counsel for the petitioner seeks 38. Yes. Mr. Chakravarti, which report?
he has filed the opposition.
You filed the opposition.
There was a direction. But my writ petition is saying that they are making illegal construction. Justice Chondo.
File your reply.
Yes, I shall file. Only a week's
Learned counsel for the petitioner seeks 2 weeks time to file his
Malum.
reply to the affidavit in opposition. Let this matter be listed in the
2 weeks, man.
After 2 weeks.
After 2 weeks,
May the report be kept on record?
but after 2 weeks, it will be 16th of April.
Just take the report on record. The opposition. The affidavit in opposition filed by respond number
10, 11 and 12.
10, 11 and 12 is taken on record.
Lord, not after 2 weeks. 2 weeks will take us to 16th of April.
4 weeks?
3 weeks. 3 week will be 20th, 16th and 17th. 2 days between a big long holiday. Lord, perhaps some difficulty would be there on those 2 dates. So let it be.
When do you want?
3 weeks. 23 तारीख होगा 23 तारीख
My petition. 39.
As a special officer, I am submitting this report, my lord.
39, my lord. I have the petition, my lord. Do you want to file exception to that? Or
there's an allegation for illegal, my lord.
Sir, do you want to file exception to
Yes.
the report of the special officer?
Yes, my lord, we want to bring some documents, my lord.
I'm not allowing you to bring some documents. I'm asking you, do you want to file exception to the report?
No, my lord, private respondent. Huh? Special officer?
Yes, what is the matter?
আমি ইয়েতে মেলে পাঠিয়ে দিয়েছিলাম পাঠিয়ে দিয়েছি
Just take down. Learned counsel for the petitioner does not wish to file. It is put to him. The special commissioner has filed his report. It is put to the counsel for the petitioner that does he wish to file his exception. Counsel for the petitioner states that he does not wish to file any exception to the report. Now tell.
No, the petitioner alleges, my lord, the illegal construction over a pond.
Yes.
The special officer is appointed for the same to visit that plot, my lord, and
What is your report, sir?
according to my report that there is a water body has already created and the measurement was ascertained the create water body of 1 kata 7 theta, that is 1035 square feet, but physically it is 1101 square feet, more than 1035 square feet there.
Our grievance is that, my lord, the water body contains, my lord, 17 cut. Now it is now 1.7, it turns to 1/10.
Yes.
Hello. The total land was, my lord, 33 kathas.
Yes.
Which includes 16 katha of land, my lord, and 17 katha water body, my lord. We have also filed a civil suit, my lord, that is pending before the court below, and my lord. We have taken total all deeds of both the parties, my lord. In their deed also, my lord, which is they are telling me that it is their deeds, my lord, in the schedule, first page, second page, every pages, it is, my lord, 16 katha land and 17 katha water body. Lastly, my lord, in the schedule of the property, it is become 30 entire land was homestead land. And on the basis of that deeds, my lord, the municipality gave them the plan, one plan. And my lord, we have everything is given to the municipality, man. But
when all of a sudden, my lord, the 116 kata land and 17 kata water body turns to 33, my lord, 33 kata, my lord, homestead land.
Yes, Mr. Mukherjee.
Without any conversion.
Firstly, there is a, so far as the construction is going on, there is a sanction plan which was granted in 23. But I do not understand, though I'm very poor in mathematics.
Same here.
I could not
My arithmetic is
appreciate the calculation of my learned friend. If your lordship kindly comes to Ballard would kindly come to page 7.
Why should we get into that?
Ballard, page 7. Paragraph 7. Then subparagraph 2. That the land measuring about 17 kathas, comma. So it says land measuring 17 kathas. The nature of the land is pond or tank. But it is should be, as per my learned friend's submission, it should be pond, land and tank. And 16 kathas is recorded as Bastu. So if I take away 16 kathas from 17 kathas, this statement is on oath. Right. So what is remaining is 1 katha.
1 katha.
Yes, that should be the pond area.
17 chatak.
Yes. And now, my lord, advanced, my learned friend has said very categorically he doesn't want to say anything so far as the special officer's report is concerned. So 1 katha is 720 square feet. Now your lordship sees the special officer's report. He says in no uncertain terms that in this relevant premises, the water body measuring about 1101 square feet. It is at page 3, subparagraph Roman 4.
On 6.
Sorry, Roman 6. So if that is a fact, my learned friend doesn't have any sentence to urge further.
Paragraph 5 onwards, they have written Mallory's stating something other.
What I'm
Paragraph
stating
5,
from other.
Paragraph 5.
I'm stating from your writ petition itself. I have not used any affidavit in opposition.
Mr. Banerjee, anything?
My lord, this was in fact the dispute petered out quite a lot before my lord's honorable predecessor. The only point that they urged was there is a 1.7 katha water body in the premises. I was covering it up. Therefore, my lord Justice Chanda was pleased to make an order. Please go and see whether there is 1.7 katha or more. My submission was that there is more than 1.7 katha today. The building is under construction in terms of a plan that will be preserved as the water body. Special officer has gone and with photographs returned a report to which he doesn't file an exception.
Yes.
Therefore, my lord, that 1.7 katha or more of water body is available in the premises today is undisputed. As far as his locus to file this writ petition is concerned, my lord, these are 4 or 5 people from Bangladesh who have been told by the civil court to appear in person because these people may be set up. A gentleman by the name of Mukhtar Aslam, a gentleman by the name of Mukhtar Alam, purporting to be their constituted attorney, has filed this petition. He has also filed a suit on behalf of these so-called owners. The suit court has, by an earlier order, directed them to appear in person because, their existence itself is under doubt. That's an order dated 10th of December 2024, passed in Title Suit 391 of 2024. Those so-called owners have not yet appeared before the suit court. So today, whether this is a proxy litigation or at all any litigation worth its name, is under question.
Oh, his power of attorney holder.
Today also there was a date. He says he's a power of attorney holder. The court wanted to have a look at his grantors. Because a Bangladeshi cannot execute a power of attorney in favor of an Indian without going through the embassy. He is relying on a purported power of attorney. This is an issue relating to maintainability.
A land, my lord, of 33 katha, my lord, 17 katha pond was now turned to 1.7 katha.
Corporation record shows 1.7 all along. He is not challenged it.
I am with their teeth, my lord.
Where have you done that, sir?
Paragraph 5, my lord.
Paragraph 5. Where? Then what is paragraph?
No, sir.
7 point.
Kindly say land measuring 70 nature of
7.2. Yes, this is what is your statement on oath.
17 katha is a pond. and 16 kata is the Bastu land.
Where is it?
And
Yes, I am reading it, that the land measuring 17 kathas. The nature of the land is pond or tank, and 16 kathas is recorded Bastu. You cannot 17 with
Okay,
16.
Mr. Mukherjee.
16 has to be deducted from 17, one remains.
no, land measuring 70 kata, the nature of.
All right, take down.
That is why, my lord, the Honorable Supreme Court said it court should not go into disputed questions of fact. Otherwise, katta-wise measurements will come up for debate. Under Article 226 of the Constitution. This is precisely why we all know that writ courts never enter into questions of fact. He has got a substantive suit there. He can ask for all the relief under the sun.
Learned counsel for the petitioner had preferred the present writ petition alleging unauthorized construction of building at premises number 7, 7A, 7B, 7C, 7D, 7E, and 7F of the Tiljaja Place Road, PS Karaya, Calcutta. It is the case of the petitioner that illegal and unauthorized construction is being carried out by the respondent number. Mr. Banerjee.
I am respondent numbers 11 to 13. Right?
Respondent number 11 to 13. Full stop. This court-wide order dated 25/2/2025 had recorded that recorded the statement of the counsel for the Calcutta Municipal Corporation, wherein he had stated that the relevant building is being constructed in accordance with the plan sanctioned by the corporation. Is being constructed, not conducted, constructed in accordance with the plan sanctioned by the corporation. It was further stated that the plan was sanctioned with the condition that the respondent number 10 to 13 shall create a water body of an area measuring 1 kattha 7 chata bracket 1035 square feet bracket close in the relevant premises. This court, by order, with this court had appointed a special commissioner, Mr. Subit Majumdar, to go and inspect the property and file a report wherein the water body, as stipulated in the sanction plan, is being maintained and is being constructed and maintained as per the undertaking given by the private respondent to the respondent, given by the private respondent to the corporation at the time of sanctioning of the building plan. Full stop. A report has been filed by the special commissioner wherein he had conducted the inspection along with the officer of the KMC department and has come to a finding that the respondent number 10 to 13 have made the necessary provision and have created a water body measuring about 1101 square feet within the boundary of the relevant premises as directed by the Calcutta Municipal Corporation at the time of sanctioning of the building plan. Full stop. He observes that there is no illegality in the said maintenance of the water body. Full stop. In view of the report filed by the special commissioner, nothing survives in the present writ petition. The contention of the petitioner that he is the owner of 17 kattas and 17 katta then?
Water body.
The contention of the petitioner that 17 kattas should be maintained as a border as water body is neither here nor there, since the sanction plan is only in dispute of how much is the dispute? One katta 17 chatak. 1 katta 17 chatak. Full stop. In view of the same, nothing survives in the present writ petition. The present writ petition is disposed of in terms of the fact that the respondent number 10 to 13 are constructing the property as per the sanctioned building plan, and the water body is being maintained as mentioned in the sanction plan as per the report of the special commissioner.
Petitioner 40.
My lord, 40, my lord, I am for the petition on early morning. I mentioned the matter for adjournment.
Yes, ma'am. Who's on the other side?
My lord, after 9, my lord, I have.
Who's on the other side? Did she call you?
How can you oppose me on this way?
No, did she call you? I'm asking. In the morning, did she call you?
No, I'm getting listening of that. No, I am for the respondent number 4, 5, and 6.
My lord, I am led by Mr. Bikashanjan Bhattacharya.
Proxy counsel so-and-so submits that the main arguing counsel is
After
in-
9, my lord, after
is
9.
indisposed. She requests for a short adjournment. Let this matter be listed after 9.
After 9th,
After 9.
I am getting.
Petitioner 41.
And I am for the municipality. In this matter, I am appearing on behalf of the private respondents.
None for the petitioner. Dismiss in default.
Will appear on dismiss for default. Dismiss for default.
Petitioner 42.
But I am for the petition.
Yes, Mr. Mukherjee.
Your Lordship, I'm on the behalf of the private respondent number 6. Private respondent number 6, Your Lordship.
But I am for the respondent number 5. But if your lordship takes up my writ petition, your lordship, my lord, there is an earlier round of litigation. My lord, the allegation was, my lord,
Demolition order, you're challenging.
demolition order. My
You
lord,
go before the appellate forum.
my lord, the appellate forum, my lord, the tribunal, my lord, in respect of Howrah Municipal Corporation, my lord,
Not there.
Kolkata, my lord, there is a tribunal functioning.
For Abra,
That's
no.
why. My lord, I'm not for the Howrah. Mr. Banerjee can, my lord, throw light on it, my lord, properly, because what I have instructed,
Go.
my lord, Mr. Banerjee's presence is required. My lord, perhaps, my lord, on the last day, my
Let's
lord,
see the act.
the report, yes, my lord, in the act,
There
my
is
lord,
a
there was a
provision of
provision,
appeal.
my lord, establishment of tribunal. In respect of
Does it exist or
Kolkata,
not?
no, my lord, my instruction is that that has not been established in respect of Howrah.
Mr. Ghosh will enlighten us. Mr. Ghosh.
Howrah,
Demolition order, Havra.
not here.
No tribunal.
That's why.
Why don't they notify the same tribunal with all the powers?
That has been notified.
That the cases of some other municipalities and corporation, and that is to be dealt with by the tribunal, my lord, of the Kolkata Municipal Corporation.
Correct.
Once it was, my lord, done, I do not know ultimately, my lord, what is the effect of that.
But that is how it should be. They should refer it to one tribunal, whether it's Calcutta, Havra, whatever.
That once the notification, I understand, my lord, that was issued, but ultimately the effect of that notice, I don't know, my lord, exactly.
One notification has been issued that the same tribunal will function in respect of Howrah also.
Show me the notification, I'll pass a direction.
That Mr. Banerjee was having, my lord, he was shown, my lord, before the court, my lord, on one day.
That was there.
So we'll have it Friday. Friday?
My lord, my Annapurna Puja at the house, that's why, my lord,
When do you want?
my lord, after 8, my lord, any day after 8.
You appear for state.
No, I am for one of the private respondents.
Nobody for state, nobody for. You ask Mr. Banerjee to be here.
I shall.
Even the junior is not here.
After,
Ask Mr. Banerjee. Not today. Just after 9th. After 9th.
After 9. Great.
After 9th, someone
11. Great.
The petitioner, my lord. My lord. Oh, right.
Yes.
My lord, before I start my submission, I would like to draw the attention of this honorable court to come to page 46 of my petition. It's a photograph.
You're the tenant.
I am the tenant. One of the tenants. One of the tenants. My lord, this is the condition of the house. 46, 45, 44. My lord, thereafter,
Nothing can be seen from these pictures.
my lord, thereafter, I would like to draw your lordship's kind attention
At least
to
put
page
colored
number
pic-
36.
Sir, why don't you put colored pictures with the petition?
The reason being, my lord, the correct pictures means I just wanted to show the photographs in order to show the
Think
condition
colored,
of the house.
colored pictures
Colored
so
pictures.
that I can see.
My lord, I will be very candid with your lordship. My lord, this is a change brief. My lord, my copy is concerned. I'm very much sorry to say this is a color
You're
picture.
privileged. The bench is not so privileged as you are. No?
I bowed down, my lord, extremely. I bowed down.
Please put colored pictures.
Should I file supplementary affidavit?
Better, because if you want to rely on the pictures,
Yes,
I
my
can't
lord.
see anything.
Yes, my lord. In that
And,
case,
previously, when the matter was taken up by the coordinate bench, where the learned counsel who appeared for the petitioner, he submits that matter no notice was provided before passing any order. What happened, matter building is a dilapidated condition. That's why we initiated proceedings. We initially served notice 411. Thereafter, an opportunity of hearing was given, and he attended. And thereafter, matter order has been passed that declaring it is a condemned building. Therefore, he has to demolish or repair. Now, that order has not been challenged before your lordship's court. Last occasion, the learned counsel who appeared, he initially submitted that matter. I have not.
You have not challenged.
my lord, that order is not challenged, but the thing remains.
That has not been challenged.
My lord, that's true, my lord. I'm not contradicting him. But the thing is, my lord, that is the reason I want to draw the attention of this honorable court to page number 36.
Yes.
Page 36 and 37. An inspection was made by intra-project organization who are well aware of the situation. They are expert in it. They made inspection and they have shared their opinion that these are simple building. A minor repair would suffice the purpose. This is under any circumstances whatsoever is not at all dangerous in nature.
If you let it
Second,
See, this court cannot get into that aspect.
my lord, I bow down your lordship. What I'm banking on is that may an independent engineer or anybody be appointed to make an inspection and file a report.
Let him challenge. for
Let a
this
clear
order.
picture, it will reveal the clear picture.
Today, a final order has been passed. You have come here because you were not given the opportunity of hearing. You have been given the opportunity of hearing. A final order has been passed. You have to challenge that order. A much water.
My
is
lord,
already
there is a
flowing.
statutory provisions. Yes, my lord, I cannot deny that. But the thing remains, I have participated, but my
Challenge that order.
but the thing is, my prayer was not been considered. Moreover,
That is the more reason that you have to file that. You have to show that from the order that your plea was not considered. The order has been passed illegally without application of mind, with a malice, with a malified intention. You have to show all that from the order.
my lord, in that situation, my humble prayer to you, my lord, may a direction be given to us so that we can file an appeal and may it be disposed within a reasonable time. As you,
There is a provision of appeal, my lord, but there is a time limit.
we have already given representation on a number of occasions.
When was this appeal?
My order was passed on 15th May 2024. The
15th May.
Yes, ma'am. That has
Just
been
now.
15 May 24. That the order is with your lordship's record. My last occasion, I have handed over to your lordship. If your lordship permit me, I can show it to your lordship from the records, my lord.
We have filed it on June 2024.
This has to be challenged before the.
Now, my lord, there are conflict judgments. Someone, I just find it for your lordship if it is with the record, my lord. But I have the copy also, my lord. I have another spare copy, my lord. This is the order and the submission was down now. The submission was made, my lord. That my lord, he was not given an opportunity of hearing, but his signature was there in the next page. This is the final order. Then kindly turn to the next page, 11th May. 11th May order was passed. Now, right hand side, your lordship will find. But kindly see column number 3.
the signature, the right-hand side page. The name of the person, my lord, column number 3, signature.
Yes.
Ivan Fernandez, my lord. Kindly see who affirmed the affidavit, my lord, at page 12 of the writ petition.
My lord, most of them are senior citizens. Most of them are senior citizens. All are around. In fact, they are super senior citizens, I should say.
Right. That's all right.
Let him challenge, let him take step in accordance with law, because there are conflict judgment that whether this will come before this court or the tribunal, there is conflict judgment. Therefore, whatever steps he will take in accordance with law.
I can dispose this off.
My lord,
With your liberty,
kindly
without
grant me, my lord, the opportunity to appear, my lord, take appropriate steps. My lord,
Liberty diction to, Your Worship.
Learned counsel for the petitioner seeks to withdraw the present writ petition since a final order has been passed. Final order dated 15/5/2024 has been passed by the corporation in regard to the premises number 77 Metcalf Street, Ward number 046, Borough number 6, under section 412A of the Calcutta Municipal Corporation Act 1980. Full stop. Counsel for the petitioner seeks to withdraw the present writ petition in view of the same and take his appropriate remedies available in law in accordance, take his appropriate remedies in accordance with law. With the above, in view of the above, the present writ petition is dismissed as withdrawn.
but my lord, the thing is, if the house is being pulled down in that time, my lord, all the tenants will be on the street, my lord.
It has not been pulled down for last 1 year.
My lord,
You know,
it is
almost.
because of the fear of this writ petition.
There's no fear, sir. You do it today, it will happen. You file it tomorrow.
And let it be kept with record, my lord, this order.
The copy of the order passed under section 412 of the KMC Act is kept on record.
My lord, may some protection be rendered for 1 week at least. Till the time we can at least approach before the appropriate forum.
Approach, my lord, let him file an application. Normally, corporation, if they approach, my lord, not doing. Since, my lord, 1 year corporation not done. 402 within
Nothing
bracket
is going
A.
to happen. 412.
412 within bracket capital A.
Bracket A. 412 bracket A.
Grateful, Your Lordship.
Grateful.
You will go after a week.
Yes, my lord. 1 week, within 1 week, my lord, I will approach.
Learned counsel for this petition, the order dated 15/5/2024 shall remain stayed for a period of 1 week from today till एक हफ्ता देखो क्या है आज क्या है फर्स्ट सेकंड till 8th April है ना till 8th April 2025 for the petitioner to refer his appeal in accordance with law.
Extremely good. If he filed the appeal, then he ought to have moved before the.
If the petitioner fails to file the appeal,
it will
the order dated, the stay shall stand vacated.
Much obliged, Your Lordship.
Petitioner 44.
But I am for the petitioner. 44 and 45 are two similar and connected matters, my lord. But it is affidavit of service. But what has happened? My
Matter
client,
settled.
my lord.
Matter already settled or not settled?
No, not settlement. My lord, my client filed an appeal before the Municipal Assessment Tribunal against a valuation determined by the authorities. But pending hearing of the appeal before the tribunal, my client approached the Lok Adalat.
Lok Adalat said, since the matter is pending before the tribunal, this matter cannot be settled. My client filed an application before the tribunal praying for transfer of the matters to the Lok Adalat. Now, their corporation objected to that by saying that there is a provision, my lord knows, my lord, 189(6), that the entire pre-deposit is required to be made. On that ground, the corporation objected the transfer. The learned tribunal rejected my contention, rejected corporation's contention also, and dismissed the application. I have challenged that order of the tribunal. My humble submission is that let the matter go before the Lok Adalat. If it is not settled, it will come back. And my lord, so far the dues are concerned, the corporation has the power to waive the interest and penalty. In the statute, it is provided. But the principal amount, if your lordship kindly directs to some extent, to the extent of 50%, that is my instruction, your, I can deposit. Lordship will kindly see the order, page 39. Page 40 is the objection, second paragraph, by the municipal authorities that the entire pre-deposit is required to be made. That is their objection. And after discussing everything, at page 41, lordship kindly sees the ordering portion. Page 41, last part, lordship kindly sees the order.
An innocuous order, what have you challenged?
But I have challenged because they can waive the interest and penalty if I go to the Lok Adalat.
They don't want you to go to the local.
Lordship, we not agreeably, Lordship.
My lord, only difficulty, my lord, the interest and penalty part, they are statutorily, they can waive.
Whatever.
Principal part, my lord,
Not that, your
Your
lordship.
rights are not getting curtailed, sir.
Lordship.
The tribunal will hear you.
Yes.
This is
Yes.
just a endeavor on your part to refer the matter to Lok Adalat, which they have objected,
Yes.
and the court has declined that.
Yes.
That is it. That is what you have challenged. There's nothing in this.
yes.
And
My
your
lord,
have-
my
Absolutely
submission,
nothing, sir. All your rights and contentions are still open before the tribunal.
yes, yes.
Argue your matter there.
My lord, only one
My lord,
submission.
One thing, your lordship, more
Oth-
than 50 lakhs pending.
Yes,
that-
I'm
To evade
submitting
that,
that.
my
My
lord, they are trying
lord,
to. but
only
we are not.
submission is that today, my lord, if I go before the tribunal, I'll have to deposit the entire amount.
Good for you.
My lord,
Good. You should
my lord,
deposit.
if I go before the Lok Adalat, the corporation
You're
can
not
waive-
going before the Lok Adalat, sir. There is no question. They're objecting. Lok Adalat is only when they agree for it.
Lordship.
Both the parties have to agree mutually. You can't compel a party to go to Lok Adalat.
Lordship.
My lord, the
There's no
tribunal-
infirmity in the order.
my lord, tribunal has rejected my application, rejected their contention also. Tribunal has not accepted their contention also.
Don't worry about their contention. They will go wherever they have to. Take down. Oof. The petitioner has preferred the present writ petition challenging the order dated 25th April 2024 passed by the Municipal Assessment Tribunal in MAA 82 of 2018. Full stop. Learned counsel for the petitioner had moved an application. Where's that application?
My lord,
Had moved an application
tribunal,
for transfer of,
yes, page 35.
had moved an application MA number 81 of 2018 for transfer of his pending appeals before the Lok Adalat. Full stop. The said application was dismissed by the tribunal on the ground that under section 20B of the Legal Services Authority Act 1987, page 40, tick to tick. So and so. In view of the given scenario and based on the material consideration, the tribunal had come to the conclusion that the respondent KMC did not concede for referring the matter for settlement before the Lok Adalat. Therefore, the tribunal had held that in a scenario where the consensual decision of both the parties are not there, no purpose will be served by referring the matter before the Lok Adalat. Since the petitioner and the respondent were not in mutual agreement for settling of the dispute before the Lok Adalat, and the respondent had objected to the same, the tribunal decided not to refer the matter before the Lok Adalat. Full stop. The matter is still pending adjudication before the municipal tribunal, wherein the petitioner has challenged the enhanced valuation effective from quarter of 2000.
My lord, this is for 4th quarter 2016-17.
Fourth quarter 2016-17 in respect of premises number 20, Pottery Road, Calcutta. Full stop. This court finds no infirmity in the order of the municipal assessment. Municipal Assessment Tribunal. Since a matter can be referred to the Lok Adalat only if both the parties do intend to settle their disputes without going through the
Take to them, please.
hustle bustle of litigation.
Sorry to interrupt, my lord. Only one line, your lordship will kindly see section 20 of the Act. If the party applies, that will also do. There is an or in between. Section 20, your lordship kindly sees, if the parties agree, that is correct. But thereafter, or if the parties, one of the parties apply.
Application is done by one party, other party is not agreeing, your lordship. How can Lok Adalat force someone?
Only this part. This much I will support.
The court had, the tribunal had further observed that the tribunal had further given its own finding that the present matter was not one of those cases which could be referred to the Lok Adalat for settlement. The reason behind the said observation was that there are huge outstanding tax dues and that the petitioner, in order to avail his remedy before the tribunal, has to make a pre-depository payment of rupees
More than 50 lakhs at
Now it is
present.
more than
of
50 lakhs
more
with
than-
interest and
more than rupees 50 lakhs. And in order to scuttle the said payment, the petitioner had filed this application for settlement of his dispute before the Lok Adalat. This court is in agreement with the observation and reasoning of the tribunal, whereby it is observed that the appeal of the petitioner can only be decided if the petitioner deposits the, what is that section, relevant section?
pre-deposit, my lord.
Yes.
189 subsection
If
6.
the petitioner deposits the amount under section
189 subsection 6.
189 subsection 6 of the this Calcutta Municipal Corporation
Municipal
of the KMC Act. Full stop. This court also finds that the petitioner, in avoid to pay the necessary dues, is seeking transfer of the appeals before the Lok Adalat. The said order does not prejudice the petitioner, since the appeals are pending before the tribunal and he can take all his necessary averments and defense before the tribunal. Full stop. In view of the same, the present writ petition is dismissed.
But the next one is the same with regard to the other valuation. The other
Same order, this may go quarter change. What is the
Yes,
quarter in that?
quarter is third quarter 2014-15 and the appeal number is 81.
Just change that, huh? Thanks. All right, other matters tomorrow. Affidavit of service is taken.
May I take that?
Under my lord,
My
Lord, may I?
What?
Lord, item number 41, my lord, it was dismissed. My lord, landed council, my lord, Somo Mujumdar's father's, my lord, sad ceremony is going on.
Application,
My lord,
restoration application, sir. File an application, I'll restore it.
my lord, otherwise, my lord, I will inform
File
the
an application, I'll restore it. File an application. Yes.
I will mention tomorrow.
Your lordship.
Tomorrow.